to enter. But I wanted to thank you and for joining us again today and welcome you to the meeting. Today's session is going to be on business practices and ethics. It's always a pleasure for me to talk to new CPC delegates for this particular session because in my opinion, this is absolutely critical, probably one of the things that you hear most often in the recruitment and staffing services industry are complaints about recruiter behavior, and sometimes unjustifiably, but I think sometimes recruiters, staffing companies, and temporary help companies get a little bit of a bad rap. While we're waiting, I think I'm going to talk a little bit about sort of the environment that we're working in, that explains the necessity for staffing companies and recruitment companies to be very focused on business practices and ethics. And that has a lot to do with a few phenomenons that occur in Canada, in North America, and in the current environment. The first is the media. The media loves a good story that is going to get them attention. And so when something goes wrong, we tend to see more bad news stories than good. So while every day millions of people are working for temporary staffing services companies in Canada, and billions of dollars of payroll are paid to happy, satisfied people, all we need is to have one accident or one person complain that they were treated unfairly, and we seem to find our way into the news. It has been a movement by some political beliefs that temporary staffing and contract staffing are bad, when in fact they are good. The storyline that we often see in the media is that temporary staffing and contract staffing is a barrier for people to gain meaningful long-term employment, when the reality is that a huge number of people use temporary staffing and contract staffing to suit their lifestyle, to assist them to find their way into the workforce, to transition between jobs, between geographical locations. It gives people the opportunity to have exposure to different types of work and industries. And a very large percentage of jobs in the temporary staffing services and contract industry evolve into full-time jobs. Sometimes people need the flexibility in their lifestyle and the mobility that fits their lifestyle. And so temporary staffing and contract staffing is the way to go. And of course, employment agencies play a critical role in harnessing this vast resource of people, 35 million people in Canada, and they develop the skills, the knowledge, the experience, and make the commitment to harnessing that resource, filtering people, and helping them to quickly and efficiently find their way into jobs. So we hear all the time about the number of unfilled jobs and job openings and how this is affecting our workforce. And it is employment agencies and staffing services that are helping to fill that void. But it is important that we all adhere to a high set of business practices and ethics to ensure that we continue to be able to become free and largely unlegislated and unrestricted to go about doing our business so that we can make a difference in the lives of the people we serve and the customers that require our services. I'm going to flip us over now. It looks as though we've got most people on board. So I'm going to flip us over to our share screen so that I can get our slideshow up and running.
Yes, it is.
Now, again, a couple of housekeeping issues. Everyone, I think, is muted out at this point in time. If you're not muted out, then please take the opportunity to click on your mute button. It looks like everyone is, just so that if your phone rings or you have disruptions, it doesn't echo in the sound for everyone here. But as I always do, I encourage you that if you have a question or a comment, or you want to participate in the discussion during the presentation, then instead of raising your hand and typing a little note that I might miss while I'm focused on our content, then please unmute yourself and jump right in, introduce yourself, and ask the question. The interaction is always good, it's positive, it's helpful, and so please feel free, and I encourage you to do that. Also, we're starting at 1 o'clock today. At 2:30, we're going to try right around 2:30 to take a 10-minute break. And again, I'll repeat this at the time, but when we do take a break, just mute yourself out and freeze your screen, or sit there and turn your camera off and go about your business. It's always easier for you to remain in the session during the break than it is to try to reconnect again. Again, today's session is on business practices and ethics. It is one of the CPC courses that are required for you to attain your CPC designation. Following, I'm just going to back screen on that one. Following the completion of 5 sessions, then you will be given a challenge exam, which is a multiple choice question format. This particular route has got recruitment and selection in it. You will have the opportunity in the fall. You don't need it, but you will have the opportunity in the fall to also take a CPC course in sales, which will follow the same format. Again, it's not important, I've said this on previous sessions, it's not important that you memorize exactly specific details about legislation, or today when we talk about when we talk about the Code of Ethics and Standards for the CPC, you memorize the exact words, but it is important to remember the concepts and to know that they exist, and to know that you can always go look them up. So when they are an issue, sorry, I've got another phone turned on here. When they are an issue, it's important that you know that they are an issue, and that it's an issue that you can go find a solution to. The objectives of today's course are to talk about some of the things that are available, the resources that are available to you through ACSESS and the ACSESS website, to identify some case studies and examples of some of the things we'll talk about in business practices and ethics, to understand the legal and professional ramifications and implications of ethical and unethical behavior with some degree of comprehensive accuracy. And we're going to explain the process of unethical behavior towards the end of it. And of course, the whole point of this is to make your commitment to uphold the ACSESS Code of Ethics and Standards, and you need to know what that is in order to make that commitment. I kind of remind you that we're going to go over a couple things that have been spoke about on previous CPC sessions, but as an ACSESS member company, the commitment is made by the company, and then vicariously through that company membership, each of the employees that work for the company are obliged to uphold the Code of Ethics and Standards. And it is the company that, once accepted as a member into ACSESS, makes a commitment to that is the key to retaining your membership in ACSESS, is to make a commitment to uphold the Code of Ethics and Standards. And as a matter of fact, it's a requirement that the ACSESS Code of Ethics is posted somewhere publicly, either on your website or in each of your offices. We've talked before about the ACSESS mission statement, which is to identify and communicate and monitor industry standards and ethical business practices. Today, we're going to be talking about those ethical business practices to positively influence and protect the regulatory and business environment that impacts member companies and the people they serve. And the important part, as I, in my opening statements to you about sometimes us, bad news is covered in the media a heck of a lot more than the good news is. It's very important that we as industry players are committed to this mission and to our code of ethics and standards, because when bad things happen or misunderstood things happen about people's employment, about their pay, about the way that they're treated in their work, and just about their fairness and opportunity in life and employment, if for some reason it's misunderstood as to what our role is, what behaviors we have, then often the result is for advocacy groups and governments to push governments to enforce or implement regulatory policies that are often restrictive and that can cause harm to our industry, to you and your success in the industry, and more particularly to the companies that we serve because of onerous, unnecessary regulations and standards in place. And we've talked a lot about some of the things that are unique when we did legal aspects that are unique to the Canadian Canadian staffing industry in terms of regulations and standards that don't exist for other industries. And so it can make us difficult to make the valuable contributions that we want to make in terms of companies. My goodness, I've not turned all my ringers off. To make a contribution to the companies that rely upon us for their efficiency and for people who rely upon us in order to get access to employment. Access to there is to promote the credibility and visibility of the industry. So that all goes to the story that I just spoke about, and also to provide member services and support. And I'm going to show you in today's presentation just a screenshot of one of the screens on the ACSESS website that you'll have access to. Now, ACSESS, by the way, because the company is a member, you are not necessarily included with a password and username to get into the user area, the member area of the ACSESS website, unless you contact Jennifer Trayer directly, tell her which company you work for, and request a username and password, and she will help get you set up so that you can have access to the ACSESS members area on the website. So when we talk about ethics, it's also known as a moral philosophy, which seeks to address questions about morality, that is about concepts such as good and bad, right and wrong, justice and virtue. It's not always just about legality and regulations, but it is about how you do things, why you do things, the impact on the things that we do that have upon other people. And of course, many things are controversial and they're questionable. But one person or one group of people might consider a behavior or actions to be unethical, while others consider it to be normal and fine. And sometimes that's a offshoot of a person's personality and upbringing and their culture and their beliefs. But there are some minimum standards that I think that we all should adhere to. And it's really important that we understand not only how we feel about these things, but how other people, when we're talking about ethics. So very often other language is used when we're referring to ethical or unethical behavior. So we talk about a person or a company or an organization's honesty, their integrity, their accountability, the taking responsibility for the things that they do and they say and how they act. We also look at things like respect, mutual respect, loyalty to friends, to employers, to customers, to candidates, to coworkers is often considered an aspect of ethical morality. Being focused on doing what's right is often considered to be a concept within ethics. being concerned about others. So, is empathy ethics? Is a person who's unempathetic or doesn't have the same capacity of empathy or sympathy unethical? Not always, except for when we don't. But once we reach a certain degree of lack of empathy or sympathy for others, then not caring can often be considered unethical. Fairness. We talked a lot about fairness in terms of employment equity, pay equity, about human rights, fairness in job opportunities, fairness in access to resources and services, are often considered aspects of ethics. Very often when we talk about leadership and people in a leadership role, that they earn their title of leader because of their commitment to ethics. And of course, we give out world-renowned awards to people who show leadership in the areas of ethics and peace and these concepts. Promise keeping, promise making, and promise keeping is considered a part of ethics. Of course, the minimum standard is law abiding. We tend to have laws written because people think that in the absence of laws, there will be unethical behavior. So laws are often, even laws about speeding. It's when it's dangerous to drive your car at a particular speed or to go through a red light. That would not only be considered dangerous, but the fact that it could cause harm to others, even though it's a driving offense, would be considered unethical. And of course, truthfulness, same as honesty. So we talk about doing the right thing. And the interesting thing is that in 90% of ethical problems we face, we know what we should do. The real question is whether we're willing to do the right thing. So it's possible when it comes to complex legislative and regulatory issues that a person or a company didn't know. That's possible. And that happens all the time, that there's some sort of odd, there's all kinds of, funny memes and interesting stories about laws that still exist or laws that were written that don't make any sense and people don't understand why they were written in the first place. And so it's possible that there can be laws or regulations that we don't know about. And most people, most ethical operators and people, once they understand what the law is and they learn, then they modify their behavior because they want to be on the ethical side and the correct side of doing things. But sometimes we know what's right and we're challenged to do the right thing. And so that's the test of true ethical behavior. So what we're going to do now is we're going to run through part one, the 11 principles in the ACSESS Code of Ethics. And I want to remind everyone that as being a member company, in order to become a member, the company needed to make a commitment to uphold and adhere to the 11 principles of the ACSESS Code of Ethics. So I've got some things on my screen here. So the ACSESS Code of Members says that as members of the Association of the Canadian Search and Employment Staffing Services, we, the members, commit to uphold this code and standards and to display it prominently in our place of business. We support the principles set forth below and acknowledge that compliance with these principles is in the best interest of the ACSESS member companies, their candidates, our employees, client organizations, and the reputation of the search, employment, staffing services profession in Canada. So we're required to post this notice and, of course, the Code of Ethics that comes along with it. So, when we're doing live presentations, we often have open discussions at this point in time. So we have these things called, that we call on the screens called polls. And so, the question here is who's responsible for ethical behavior? And the answer is probably everyone. The recruiter customer, candidate, employee. We expect our employees to act ethically in the way that they represent themselves to us and how they act with their customers and their coworkers. Our candidates need to be honest with us. Our customers need to treat our people with dignity and respect and within the law. And of course, us as recruiters need to do that. So first off, principle one. We will observe the highest principles of integrity and professionalism and fair practice in dealing with clients, candidates, employees, and all regulatory authorities. And we will respect the confidentiality of records in accordance with the law and good business practices. So this is principle number one, the overarching statement. It says that we're not only going to be dealing with regulations and legislation, but we're going to be dealing with principles of integrity, professionalism, and fairness with everyone that we deal with on the client and applicant side of business. So some examples of some good, so when we're talking about good ethical practices and bad ethical practices and upholding integrity, our code of ethics, we talk about maintaining promises of confidentiality. We're making this promise of confidentiality very often to our customer, that we're going to protect their confidentiality about the things that we learn about that are going on in their business, why jobs are available, what's happening inside the organization, who's getting promoted and who's getting demoted. And also with respect to the legislative areas of privacy about people's personal confidential information that we're not supposed to share without permission. So we need to always seek authority for the disclosure of personal confidential information. And I know that sometimes that's difficult, especially for headhunters, for executive search consultants who are not necessarily relying upon receiving a resume and having an application, but what they're doing is they're working a Rolodex. They're picking up the phone, they're talking to people about their aspirations and about their history and about their career and their wants and desires and how they feel about their job and how much money they make and how much money they'd like to make. And the recruiter is making, detailed notes about that candidate with hopes that someday they can approach them with a job opportunity and treat them as a candidate. And so a lot of these things are really kind of unofficial conversations. And so disclosing people's names and information about them without authority would definitely be a breach of an ethical standard. And so we've got an obligation to protect the integrity of that information. Knowing and complying with all legislations and regulations, I think that's pretty straightforward. This is the bare minimum, knowing what we need to do with the Employment Standards Act and Human Rights Act and pay equity and all of our payroll obligations and other things are really important. Honoring contractual terms. So very often there are contracts written between people, and after time, people start to think that maybe that contract isn't fair and that they need to renegotiate it. Well, renegotiating a contract term is perfectly fine. Attempting to renegotiate something is perfectly fine, but unilaterally ignoring or not honoring contract terms is not only unethical, but it is contractually illegal. We talked in our last session about equality, fairness, equity, and respect. So these are principles that are important in every aspect of life, and particularly important and poignant and obvious when it comes to the aspects of employment, recruitment, selection, hiring, promotion, and other areas of employment. Honesty and accuracy in our interactions. So supplying accurate information to our customers about our candidates, or supplying accurate information to our candidates about the jobs that they're applying for is important. So, the corollary of that, the opposite of that is, what are some examples of some unethical behaviors? So, for example, neglecting to perform reference checks or falsifying references when filling an order would be considered unethical. The misclassifications of workers as an independent contractor and therefore not making the legal deductions and avoiding other employer obligations is not only illegal, but considered to be unethical. Direct recruiting a candidate that was previously placed by you is an absolute no-no in the recruitment and staffing industry. And quite frankly, I think that this gets more attention than it probably deserves, because it's a very, very rare violation that even the baddest actors would perform. But it only needs to happen once, and then it scars the reputation of the entire industry. And so I don't know how many people believe that this is a common practice, when I don't really, I don't really, after being in this industry for almost 40 years, don't really know of very many cases where this has clearly happened. But certainly this is a perception or a preconception and a misconception that candidates and customers have about the recruitment and staffing services industry. Lying to a customer about a candidate's absenteeism, about their lateness, about their job performance, or is failing to disclose in our industry when you have accurate information about that, would also be considered a misrepresentation. Contacting a candidate's current or former employer for a reference check without permission or knowledge would be an example of a violation of ethics. And I don't think I need to go into the details of this, but we need to be aware of the implications of our actions. And if we think that we're just going to expedite things and, oh, I know somebody at that company, I'm going to call them and what they think about Bob or Mary, that by making that phone call or asking the question, we can be putting that person's career, their employment, their future, their income, their ability to feed their children at risk and on the table, because we don't know and cannot anticipate how a person in another role in another company might act or react, and they don't have any obligation whatsoever if they're asked to do a reference to protect the information. So by calling a person and asking their opinion about a candidate without their permission could seriously cause harm to that candidate. So it's important that we get permission before we did so. So there's some examples. Now here's an example also in a poll question. So let's pretend we're having a open conversation. Your customer, ABC company, spends $800,000 annually on temporary staffing and contract services and contacts you with a 4-month order. They indirectly hint that you restrict acceptable candidates on a discriminatory basis. So you got a very important customer. You don't want to lose them. They spend a lot of money with you. They help pay your bills, and they hint that they have got some criteria in their order that is discriminatory. So we've got some choices here. Take all the details and emphasize that you will work hard and provide the best candidates possible based upon required skills while adhering to non-discriminatory practice. You can see that number A is bolded because that's the right answer. The other answers, which might seem okay, maybe, but probably not, are not. So some examples of what not to do are to ensure that you get a detailed request in writing so that you can blame the customer if you're caught discriminating. Well, that's not good. Hand the assignment to a tenured recruiter who is less uncomfortable with cooperating in discrimination, specifically to a top client. That's not the right answer. Hand the assignment, go along with it if the discrimination does not relate specifically to a legally prohibited ground. So, for example, if they said we only want good-looking people, physically attractive people. Incidentally, physical attractiveness is not a prohibited grounds under the Employment Standards Act. So, of course, actors and actresses and models and people are hired and become famous because of their good looks. But that would be in what I would consider to be an unethical criteria, not necessarily an illegal criteria. And so you want to take that into consideration, that you may be asked to be doing something that's, although not illegal, is unethical. And by the way, when asking people for physical attractiveness, you may be implying something that is illegal, like gender or age, for example. Inform the client that they will be obliged to use their company specific criteria after you have given them a short list of candidates. So in other words, that answer E says you're going to ignore what they say, send them candidates anyways, and let them make the final decision. Well, of course, the customer always has the final decision, but I think that number A is the important one. And I want to give you some examples of ways to deal with a customer giving you a discriminatory order. And the conversation might go something like this. I understand and hear what you're saying, but what I think you're telling me is that you believe that there are characteristics in a worker or an employee that are very important for this job. And I think what we need to do, and I hope you agree, that what we need to do is focus on those characteristics that are important for the job and not necessarily assume that they are associated to something of prohibited grounds, like gender or place of origin or age or sex or sexual orientation or nationality. Those would be overgeneralizations, probably not accurate in a lot of cases, in most cases, and certainly illegal. But it is not illegal, and it is appropriate for us to determine what the characteristics are that you're looking for, and we will focus on those characteristics while hiring. Now, that might be too much. That might not be enough. I think every circumstance is different. But the important thing is, and I think maybe I'm giving people too much credit, but I think the error that is made by a lot of people is that they first make the error in believing that a particular group of people possess similar characteristics, and the whole notion of human rights and the prohibited grounds is that that's not true, and that shouldn't be taken into consideration. But it is okay to say that we want people who are energetic, or we want people who are smart, or we want people who are able to work, long hours, or within the scope of what's legal in employment standards. We want to have people who are kind or considerate or hardworking, or whatever the characteristic might be. I don't know, that whatever characteristic might be, the person is inaccurately associated to a group of people or not to a group of people. What's important is that we figure out what those characteristics are that make for a good match, and that we hire based upon those characteristics, not based upon the group of people that they improperly believe those characteristics are associated to. So principle number 2, we will provide leadership in the adherence to both the spirit and letter of all applicable human rights, employment laws, and regulations. We will treat all candidates and employees without prejudice, and will not accept an order from any client that is discriminatory in any way. So we just talked about the examples of a customer giving a discriminatory job order, even if it's implied and not specifically stated. And we just gave an example that may not be a perfect example of how we requalify that order and the details of the order so that it does not contain illegal and inappropriate and unethical criteria. So we've had more detailed explanations of human rights legislation in our previous sessions, but just as a reminder, we've got prohibited grounds include things like age, creed, religion, disability, family and marital status, gender identity and gender expression, race and related grounds such as color, ancestry, place of origin, ethnic origin, citizenship. Receipt of public assistance is something that we didn't talk about, but receipt of public assistance is prohibited in things like access to housing. We talked about record of offenses, and that only when there is a bona fide occupational requirement and that the person has and it is an offense that they have not been pardoned for. We talked about sex, including pregnancy and gender identity. So these are all areas that we need to take into consideration when we want to be concerned about receiving, accepting a discriminatory order, and also in our internal practices. Now, by the way, I'm going to tell you a story that is at least 30 years old, but it's an industry-related story. In the late 1980s, mid-early 90s, a fairly prominent temporary staffing company was investigated by the Human Rights Commission because they were using codes on their applicant tracking system. And the codes were originally intended to say things like good candidate, not, a great candidate, definitely use, avoid this candidate. And of course, you can say avoid this candidate, because if the candidate has been dishonest or has had a bad reference check, you can put a code on there, except for codes are misunderstood and misused. And so there were, over time in this company, internal employees, and I don't think with the specific knowledge of the ownership and senior management, these codes between some workers took on meanings that were not their original intent. And so an example of something that we want to avoid are uses of codes or words that are not specific in our evaluations of our candidates. So we're not only are we concerned about, one, does a customer give us a discriminatory order? We're also concerned about the practices that we hold inside our company so that they cannot be used or misused in an appropriate way. And that includes things like, the manner in which and the questions we ask and the information we document when we're doing interviews. So these are all aspects that require some degree of understanding with respect to avoiding discriminatory hiring and recruiting practices. So here's an example. A client requests that we recruit millennials for a role of designer. The company is a startup and they request young, dynamic people to work with them. Of course, that notion of young and dynamic, and by using the term millennials to pick a group of people by age, would be discrimination by age. A client indirectly hints that the recruiter only present female candidates for a front reception role. Again, that would be discrimination by gender. A client has a role for a forklift operator, and they must have their forklift license, which is fine. Bona fide occupational requirement. Must be able to lift 15 pounds, which is fine, well within the limit that are, there's certain limits that are established within the Employment Standards Act and workplace health and safety legislation that people aren't even allowed to lift. But they request that they have Brian back because Brian has been sent there before and Brian's a good worker. And that's perfectly acceptable too. Is Brian available? Do you think you can send him? And of course, that would be for reasons of the fact that he's knowledgeable and experienced and they're familiar with him and it's less risky. And there's no aspect of discrimination with respect to that. But then, if he's not available, can you recruit another person just like Brian? And that's where, of course, for the areas of gender discrimination, the issue falls apart. Principle number 3. We'll take all responsible steps to provide clients with accurate information on each candidate's employment, qualifications, and experience, and we'll only present those candidates who have been given us authorization to represent their application for employment. So the first notion here is, are we giving the correct and accurate information to the customer? The second is, are we giving all of the relevant information? Because remember, I said earlier, withholding pertinent information about a person's behaviors or tenure or attendance or quality of work or experience with their supervisors or honesty. Withholding that would be misleading and inappropriate. And then finally, to the other point that I made earlier about getting authorization to represent. This is probably, in my opinion, the most common error that agencies, recruitment companies, and staffing services make is that they present resumes and candidates to people with the express consent of the candidate. So, getting a general consent saying, yeah, you can send me anywhere, probably would send my resume to anybody, send it anywhere, probably would might hold water for a very short period of time. But getting a blanket authorization on an application where they sign off and say, yeah, send my resume everywhere, I think that over the course of days or weeks, start to lose its credibility. And so if a person says, yeah, send out wherever you can, and so you present it to 3 customers this afternoon and call the customers, that might be the extent of what that authorization is. So usually, without having a specific conversation or get some approval, we do not want to be just sending resumes out. So, customers' VMS, vendor management systems, where you upload resumes, is probably the place where this violation is likely to occur most, because the customer's system, promotes the notion that we need to get those resumes on record first. So if you've got a good candidate, you upload it to the system, then call the candidate for approval, only to find out maybe that candidate's resume was uploaded yesterday by another employment agency or supplier, or that they're in the middle of direct interviews with that particular company. So sometimes we can be enticed by customer need and by their systems to behave inappropriately, but we need to get approval. So here's a case study called the Treaty Group. Now, this is an interesting one because when this instance occurred, I was hired by the employment agency to be an expert witness and to write an expert report on the issue. So I happen to know probably more than I should know about this particular case. It happened a long while ago, I think around 2005 or 2008, I think it might say in a screen. This particular case, why it's, we like to use landmark cases to make the case to use that look a little old. If a case is used and a decision is made and then it's used by 10 or 20 or 30 or 50 or more court decisions later on, they often rely upon the precedents that was set with a case where the circumstances are nice and clean so that they can be carried forward in law and used again and again. And so in this case, a placement agency suggested that an employment of an employee they presented a candidate to a company without checking the employee's references or the candidate's references. The company hired the candidate to become an employee, and she worked for the company for 2 years. After the employee resigned, the company became aware of the fact that the employee had been defrauding the company. She had been stealing money all along. And the company sued the employee and obtained a civil judgment against her. So they won the civil case that she owed them the money back. And additionally, the company sued the agency for negligence on the basis that the agency did not conduct a reference check or a background check of the employee. And so in this particular case, it was found that prior to joining this is 2007. So prior to joining the Treaty Group, now, by the way, the Treaty Group is a leather company that makes clothing and bracelets and jewelry and things out of leather. Prior to joining the Treaty Group, the employee in question had twice, not once, but twice, been criminally convicted of fraud against previous employers. After joining the Treaty Group in their accounting department, of all places, the employee had stolen an additional $263,000 spread out over the 2-year party. So they reported it to the police, and the employee was convicted criminally. And as mentioned on the previous screen, they went to court and they obtained a civil judgment against the employee. And in a separate action, the treaty group also sued the agency severally. So we talk about joint and liability in a tort or in a contract dispute. Joint responsibility means the two parties are joined together and that they've got shared responsibility. And several responsibility means that there are two parties, each of which share in contributing to the loss or the liability. So in this particular case, they were sued severally because they weren't operating together. They were operating separately, and the agency had been duped. At the trial, treaty group was successful against the agency also. Not only were they able to get a judgment against the worker, but they also were able to get a judgment against the agency. And although its damages, the damages were awarded again for the $263,000, but the damages upon appeal were reduced to 50% because, no, actually it was not upon appeal. It was in the original judgment, were reduced by 50%. So half of the 263,000, because it became obvious during the trial that the treaty group had its own degree of negligence in failing to put into place appropriate internal financial controls to prevent this kind of loss from happening. So they were negligent or irresponsible in not overseeing the employee and their work process. And the agency was negligent in overlooking the application process. Now, I'm going to give you a little inside information. The treaty group, as the story goes, and what I saw when I was doing the expert witness report, was that they, prior to using the agency, hired a consultant to help them. And I think that they probably, where's all our money going? What's going on here? Or, you know, we need to be more efficient. Do we need to hire? This is before the loss. You know, we need to be more efficient. And so the consultant assisted them with some organizational review and possibly creating the job description. And the consultant told the agency that the consultant wanted to do the reference checks, which is fine. That they want to also do reference checks or be responsible for the reference checks. But in this particular case, neither the agency nor the consultant performed the reference checks. And in fact, there was some evidence in the case that the agency recruiter made a call and didn't get information from a previous employer, but wrote something down on a piece of paper in handwriting that implied there might be a problem, but didn't get any details and can't be certain about what that note meant. And so it appeared as though the agency, one, didn't do what they said they were going to do, and two, may have had a motive to turn a blind eye. And so they were found to be guilty. Now, one of the interesting things in this particular case was that there was no contract that was written between treaty group and the agency. So a lot of what happened in the court case was about what are the industry standards, because you can have an implied contract. Two people can shake a hand or talk, and there can be certain standards that exist in the sale of a car or the purchase of a good or the work done on a house that isn't in a contract, but if it fails to meet certain minimum industry standards, that can be deemed to be a violation of the contract. And so a lot of what happened in this case was that the treaty group relied upon what the agency had posted on their website about the things that they do, which included reference checks. And further, and what the industry does, which is promises to select people that are a good fit based upon their previous employment experience, education, knowledge, so on, which implies reference checks. But they also made the mistake of misusing language and interchanging the words background check with reference check. So a background check is a more generic term that typically holds different types of checks: verification of employment, verification of credit worthiness, verification of their criminal record, verification of their previous income, reference checks, other things that are included in a background check, which is a more generic overarching statement than it is specifically a reference check. And so what happened in this particular case was the agency misused the word background check when they specifically meant reference checks, and then neglected to do the reference check anyways. So in this, there was no signed service agreement. There was an intermediary consultant who I described to you as responsible for vetting candidates. There was a difference between reference checks and background checks. There was the possibility of dishonesty regarding the reference findings. So that's the implication that one of the reference checks resulted in the handwritten note. There were questions about what the industry norms and standards were. There were what the agency had posted on their website, which is the implied terms of the contract. And then there was the client's lack of checks and balances in their own process. And then finally, there became an issue with the calculation of what the damages were at the end and which party was really responsible for it. Examples of what not to do. One of the things about talking about business practices and ethics is we tend to focus a lot on what not to do, which implies what we should do. And I sometimes think what we should be is talking about what we should do, and which implies what we should not do. But we should not make up references or ignore unfavorable ones, alter or fail to disclose unfavorable test scores prior to presenting a candidate. We should not seek out approval from a candidate to submit their resume. We should not seek out, so double negative. We should seek out approval. We should not avoid seeking out approval. We should not falsify background screening and skill levels and so on. Principle number 4, we will supply candidates and employees with complete and accurate information. So before we talked about supplying customers with complete and accurate information about our candidates, and principle number 4 talks about supplying the candidates and employees with complete and accurate information about our clients regarding the terms of employment, job descriptions, workplace, and conditions. And we also, in a previous session, in our legal aspects, particularly in Ontario, it's written right into the Employment Standards Act, the list of minimum information that is required to be provided in writing to a candidate before they're sent to a temporary assignment. That legislation does not exist with respect to the information that must be provided in writing concerning a candidate that is sent for a permanent job. But on the temporary help side of things, there is a legislative list of information, which includes your name, your legal name, your registered company names, the customer's name, the customer's legal registered company names, the contact numbers, and so on. And, a lot of times we try to protect our customer from being interrupted by our candidates and by our temporary and contract workers. And so we don't disclose that information. But interestingly enough, under the law in Ontario, we've got an obligation to provide that contact information. Case number 2, we place an employee, it says case number 2, I think this was case number 3. We place an employee with our client as a data entry operator, basic alphanumeric key punching. When we key punch, that shows how old I am. When we contact the employee a few weeks later, we find out they're not only doing data entry, they're also using MS Project to track milestones for their manager and working in Excel and creating pivot tables and running analysis weekly on charts and doing more sophisticated work. So was there a breach of ethics here? I mean, if the client knew that they wanted a more sophisticated, experienced worker to perform more sophisticated, experienced tasks, and they described it inaccurately as alphanumeric data entry, then that would be a violation of ethics, honesty, and integrity from the customer. If the customer hired a person to do basic alphanumeric typing and found out while they were there that the candidate had a greater degree of skills, and so they started allocating more and more different types of work to the person, that's not a violation of ethics. At some point in time, if it's 2-week, 4-week temporary assignment, not giving a person a pay raise during that 4-week assignment where a contract was signed and agreed upon for a pay raise for 3 or 4 weeks wouldn't necessarily constitute unethical behavior, unless, of course, the example was that I gave earlier, that they knew what they were doing. They were trying to fit somebody into a lower pay grade with the hopes that they'd eventually get sent a candidate that they would accept who could do more sophisticated work. But if it just so happened, that's not a violation of ethics. If you have that person doing that work for a long period of time, and the person sitting beside them is doing the exact same work in a different pay grade, then that pay inequity would be considered to be a violation of ethics. And so in this particular case, there's nothing unethical, inappropriate, or a violation of the code of ethics on the face of it as we look at this. But as time goes on, and if that job description changes, and if we've got a pay equity issue because a person of a different gender doing the exact same job is getting paid in a different rate than a different gendered person doing this job at a different or lower rate, then that would be a pay equity issue. Or if this person is of a different race, creed, color, sex, sexual orientation, disability, or something, and they're doing exactly the same job over a period of time, then that would be a violation of human rights. But on the face of it, if it's a 1-week or 2-week assignment and they got hired to do something, and it turns out that they can actually contribute more, then no one went into this with the specific intent, and the time frame was so specific that it's not. So this is an interesting question that has the potential to become an ethical violation, but on the face of it, right then and there at that moment, is not. The Ontario Employment Standards Act requirement: a temporary help agency is required to provide the following information. So I spoke just 3 minutes ago about what is required in Ontario with respect to the closure of information. So this is a list of the information that is required in law that must be provided in writing to every temporary worker prior to them attending a new temporary assignment. So the legal name of the client, plus any of their operating names. So, you might be working for a brand. I don't know. You might be working for, a Pampers at the parent company. I can't remember who the parent company is at this point in time. You might be working at a brand company underneath the parent company. It's important that if we have that information, that we disclose it. Who the client is, what their address is, what their phone numbers and contact names are, the wages, any benefits and commissions that are going to be paid, the hours of work, the general description of the work, which goes to the example we just had about data entry, the estimated term of the assignment. We really want to have an end date if it's possible, if known, when the offer is made, the pay periods, how off pay is made, what pay dates are. The information can be provided verbally when the work assignment is offered, and then must be provided in writing as early as possible. So you can call a candidate, say, hey, I got a job for you. You want to go? You can confirm it all, send it to the customer, put it into your system. Just make sure that they get that information at their earliest practicable opportunity. Principle number 5, checking time. We've got 30 minutes before our break. Check principle number 5, we will not recruit, encourage, or entice a candidate whom we have previously placed to leave the employ of our client. So that's the head hunting from our client place candidate notion, but here's an interesting one. Nor will we encourage or coerce an individual to leave any temporary assignment. That means any temporary assignment they're working on from us or through another staffing services company before the stated completion date. So let's look at some of these examples of what we mean by that. Under what circumstances would you entice a candidate or employee who's been previously placed to a client site to take another role you were working on? Well, the answer is under no circumstances. So let's take a look at what we've got on this poll. When you place the candidate at the clients and the client position has turned out to be less than the client promised. So you place the person into a job and the candidate is disenchanted or dissatisfied. It's not what they thought it was going to be. Does that give you the right to go back in and recruit that person out of there and charge a fee for them, place them somewhere else, and cause harm to your client? The answer is no. You don't. You probably should try to work things out with your client and your candidate, try to keep things in place, make everybody happy, act as a consultant, but not blindly recruit the person out of there without the customer's knowledge. When the candidate employee approaches you saying he or she will be leaving anyways, and trust you to help them choose their next direction. And the answer to that is, while you're working for that company, I cannot assist you. It's a violation of my code of ethics and standards, and it's probably appropriate for us to try to figure out how we resolve your issues with your employer. I can at your request, help you to do that, or try to help you to do that. But you do not want to give that candidates the impression that if they quit, they should show up at your door tomorrow. They might show up at your door tomorrow anyways, which is a different issue, but that would be considered coercing or encouraging the person to leave so that you can have them back as a candidate again. When the person is obviously unhappy in their current position, so just because of their unhappiness, again, same answer. Doesn't mean that you get to recruit them out of there and double charge the fee and cause harm to your client. If a client is planning a layoff, sometimes in the near future, if a client contacts you and says, we're considering a layoff in the near future, and there's a pretty good likelihood that the last in, first out are going to be affected by this, do you think that you can help us to replace Mary or John somewhere else? We feel bad that we only hired them 3 months ago and that they may get caught up in this. The answer is sure, of course, but only in the openness and with the permission of and the encouragement of the client. But just you happening to know or think or believe there might be layoffs is not sufficient enough for you to recruit the person. So the answer is no, under no circumstances is. So we have terms and contracts we call anti-rating clause, direct recruit clauses, fiduciary duty clauses that often customers put into their search agreements that they give to their employment agencies to not recruit not only the candidate that you placed, but also other employees within the organization. So the ACSESS Code of Ethics doesn't say you won't recruit people from your customers' clients. And clearly, if there's only 5 banks that exist in the country and you specialize in banking, you're going to be moving people from one bank to the next. But the important thing is 2 aspects of law, 3 aspects of law. And the first is that you, law and integrity. The first is that you do not recruit and attempt to place, coerce, or entice people that you've previously placed there to leave their employee. That's number 1. Number 2 is that you do not unfairly use information that has been provided to you in confidence that would cause harm to the customer because they trusted you by sharing confidential information and asking you, paying you to participate in your part of your duty to help them to grow and keep their employees there. And third is contract law, that you've signed a piece of paper very often that says that you won't do that. So discussion, what to do. Recruiter needs to fill another role as soon as possible, and the margin is higher in this other role. The recruiter wants to pull an employee from a national account where the profit margin is low. So this is a temporary help or contract placement situation. Got a candidate out working on assignment at a low margin, got a high margin job over here. The answer is no. The Code of Ethics says that you will not encourage or entice a person to leave their contract prior to the natural end, the designated end of the contract. Now, listen, I'm also in the home healthcare business, and we own businesses that do that, and we are very rigorous about the end dates of our contracts. So in our business, if we said, hey, we're going to send a person to go work for a week at a hospital, and that week was up, and during the course of that week, we had in the following week a contract or replacement at a different hospital, we have no problem in going to the candidate and saying, hey, when you finish this assignment on Friday, we've got a new one for you to start on Monday. And there's no problem in saying to client number one, hospital number one, when they say we want to extend this for 2 weeks, say, geez, I'm really sorry, we can't do that. We've already committed that employee to a different hospital for next week. There's no problem with you taking that position because those are scheduled end dates and the natural completion of the job. Now, the right answer is maybe we can find somebody just as good and appropriate for customer number two and keep the person in place number one, and everybody will be happy. But that's a customer service and business decision. It's not a violation of the Code of Ethics. But asking a person to leave early to go somewhere else is. The employee tells you they have another opportunity and they want to leave the assignment. Well, what do you do? Why are you leaving? What is your motivation? Can we fix this? Is there an opportunity for us to keep you longer? Can we negotiate what an appropriate notice period would be? Can you help participate in the training and change to a new person? Is there a pay issue? Is there a work-related issue that we can help you to negotiate? So it's not unethical for a person to resign. That happens all the time. The question is, what role do you play as a consultant to try to make it the best outcome for the employee and the customer and for your company? The recruiter locates a candidate who is currently working on a competitor 3-month assignment, and they would be perfect for your job order they're working on it, and could pay them an extra $1.50 an hour. So there's nothing wrong with a person applying for a job with you and telling you, I need to give my employer 2 weeks notice. So they applied to you, said, I want to leave this job as soon as possible. I'm very unhappy. I just want to give my employer a week's notice or 2 weeks notice. That's not coercing or enticing. So that's not a violation of ethics. But if you call that person out of the blue and say, hey, what do you do? How are you doing? Can I entice you to leave that job if I can pay you more money? Would you be interested in leaving that? And you can give them notice. That would be a violation of Code of Ethics under ACSESS Code of Ethics and Standards. Principle number 6, we will not restrict the right of a candidate or employee to accept employment of their choice. So what this boils down to is really the issue of us not creating a barrier to a candidate to accept a job. So if we say to a candidate, if you quit, we're going to penalize you. Or if you take that job with our customer, we're going to charge you a fee. Or if you take that job with the customer, we'll never help you again. We'll remove you from our list, and so on. If you threaten people to do things that are normally within their right to choose who their employer is. Now, this doesn't stop you from having a contract with a customer that says, if I provide you with candidates, you'll pay us for them. But that's between you and the customer. It's not a three-part agreement. The candidate said, I'll give you the right to present me, and I'll give you that, which gives you the right to charge the customer a fee. But if the customer refuses to pay the fee, you can't say to the candidate, you can't go. You've now got a legal issue between you and your customer, but not between you and your candidate. The same thing goes with respect to a candidate who's working on a temporary assignment wanting to apply for a job with their customer. You might say to a candidate, hey, we really appreciate it that if you see a job available with the customer while you're working there, because you're going to have access to information and see the postings internally and so on, if you're interested in one of those jobs, that you are open and transparent and you contact us, because we may have a way to help you, or we may have a contract with the customer that means they need to pay us, and so we can make all that work for you. But you that's different by talking about people what your process is that's in everyone's best interest, to saying you cannot apply for jobs with our customer while you're there. Furthermore, in the province of Ontario, which is the only province that this next thing exists, it's illegal in the province of Ontario to charge a fee to a customer after 6 months have transpired from the first date that you introduced that candidate to the customer. So some people would like, for political reasons and other reasons, would like the world to believe that a recruitment agency fee is a barrier to employment. That's like saying a real estate agent's fee is a barrier to housing, or maybe even so, a dentist's fee is a barrier to good oral hygiene. It's that's ridiculous, but it is a barrier if the fee is charged to the candidate in the issue of agency recruitment or a reprisal of some sort. Principle number 7, we will not misuse membership privileges for the purposes of recruiting members, staff, the association's staff, or in any way that may otherwise inure the candidates or employees of the competitors. So we will not misuse the membership privileges for the purposes of recruiting a member's staff. That means you won't join ACSESS and then go to ACSESS events like conferences and chapter meetings, or download lists of members so that you can go ahead and headhunt, recruit, or solicit the employment of your competitors. That doesn't mean that you can't post an ad and somebody from one company applies to another company. That doesn't mean that you can have a great reputation and people can apply to you. That doesn't even mean that you won't headhunt people. But what it does mean is that you won't be using the fact that you're a member of ACSESS to get access to member privileges, like attendance at a meeting, attendance at a conference, access to lists, participation in committees, so that you can use that privilege in order to recruit another member's staff. True or false? The company agency you work for has just experienced 90% turnover in their branch and needs to recruit ASAP. ACSESS has an association meeting that evening in your area, in your chapter, so you attend to ensure that everyone knows you're having immediate. So that's true. You're not allowed to do that. That's an unacceptable behavior. So even though, going to an ACSESS meeting and talking about your job openings would be considered an inappropriate behavior and a violation of principle number 7. Principle number 8, we will derive income only from clients and no direct or indirect charges to candidates or employees unless specified by a license. So you know what? I think that it's possible that You could have some kind of license, like you could operate a school that you're licensed to do certifications of security guards or personal support workers or dental hygienists or some other certification. You might have a license and you operate two businesses, one for training and certification, and the other one acts as an employment agency. And my suggestion is that, even if you are operating under a license, back in the day, way back when there were outplacement firms, there were also employment agencies, and they would charge candidates, people, outplacement services. And in other words, we'll teach you how to find a job, take our course. And the suggestion is don't do that. There's no way that you can operate those two businesses together under the same name, under the same thing, getting candidates apply for jobs, then try to sell them that other service that doesn't look, smell, and taste like it's a violation of ACSESS Code of Ethics Principle number 8. And in certain provinces, there's no way that you could prove or even make the case that that wasn't a violation of their laws. So make your money from charging customers, companies, organizations, governments. Do not make your money from charging candidates. Principle 9, we will maintain the highest standards of integrity in all forms of advertising, communications, and solicitations, and will conduct our business in a manner designed to enhance the operation, image, and reputation of the employment, recruitment, and staffing industry. So not only does this mean just your job postings and advertisings, but it also means your website and your social media accounts. So when we're looking at advertising, we're looking at places like Job Banks and Job Boom and Monster and Indeed and Jobs.ca and Glassdoor, Career Builder and Indeed and Facebook and Insta and Zoho and Bullhorn and ZipRecruiter. These are all platforms that can be used as a combination of an applicant tracking system and a job posting system, and can also have company profile pages. Make sure that that information is up to date, that it's accurate, and that the only post open jobs. It's okay to have a posting that says our company specializes in the placement of these particular kinds of person, and we have a constant change daily or weekly in the jobs we're working on with a variety of customers. Contact us to become registered with us as a candidate for the various jobs revealed. It's okay, but word your job in what I've used the term, the evergreen posts. Those jobs are available. And then you've got job openings for them. So you can have evergreen posts, but word it in such a way that it's evergreen, that you're not implying this is for a very specific place and a very specific job or role. And when you have open jobs and they're closed and they're filled, take them down, replace them with more accurate and up-to-date ones. If you're going to put pay rates on there, make sure that they're not exaggerated, that they're accurate, or don't put any whatsoever. That's okay too. Be careful with unintended or implied violations of human rights. So things like recent graduates, energetic. I don't know, energetic. I'm not sure if that means young. I don't know what that means. If you need to work long hours, you can say to have the energy to work long hours, willing to work long hours. But, be careful that there isn't some even unintended interpretation of the wording that you use, because very often particular groups and particular human rights advocates start to see patterns in wordings and expressions, and to them it means something. And so make sure that you intend to say what you mean to say what you intend to say, and avoid saying things that might be expressions or colloquial uses or uses of words that mean something you don't intend. Try to protect your client's integrity. When you're recruiting, you've got often an obligation to protect your client's identity, and also when you're advertising, protect your candidate's privacy. Try to acknowledge applications when you're advertising and recruiting and put things on your Facebook page and other social media accounts. Try to acknowledge the fact that people have applied and not let them leave hanging. Pay attention to things like the format that it's posted in. So I'm going to give you this terrible example, but this is not a violation of code of ethics. This is a bad business practice that people type things in shorthand and make mistakes and put spelling mistakes and grammatical errors in their jobs. But also let's consider things like applicant tracking systems. So for example, let's pick Bullhorn. There's a very popular ACSESS applicant tracking system that also has got other features: job order management, candidate management, integrations to payroll, timesheet management, customer contact and marketing tools. In many applicant tracking systems like Bullhorn, we enter a job order that we're going to recruit and match candidates against, and you can post those jobs to the internet. Sometimes, often, unless it's edited, it will post the job in exactly the format that it is put into your applicant tracking system. So there may be confidential information included in that job posting internally that is important for the recruiters to know, but should not go out to the world and posted on your website or on social or on job posting sites or on social media sites. And so reviewing those jobs in advance to make sure that we're not inadvertently, accidentally just allowing for an automatic XML upload or something to the website by clicking a radio button that says, yes, post to the web or post to my job board, doesn't inadvertently or accidentally post private information or inappropriate information. And secondly, when a lot of the tools that we use that are supposed to aggregate our job, and we use the term aggregation to mean that we create the job in one place, or propagate, that we propagate that job in a number of places. So we post it in a number of places based upon the one starting job. So we might enter it into Zoho, or we might enter it into our ATS like Bullhorn, and then click, and it propagates out to many other places. That very often the wrapping on those and the format is lost. And so we might see run-on sentences, no breaks in paragraphs, things that run off the page, things that don't fit perfectly on the page. So be careful when you're using your ATS applicant tracking tools and other propagation tools, which are awesome for efficiency, but make sure. So, a perfect example of that, in case I'm losing you on this one, is, you might have your Instagram account hooked to your Facebook account. And if you post something to Instagram, it automatically goes to your Facebook account. But because those two companies are owned by the same people, they've designed a nice integration so that something posted here looks really nice there. But if you wanted to post to LinkedIn or post to Twitter, you might see that entire thing fall apart. So review your postings on all the platforms that they propagate to or they aggregate from, to make sure that they are put in a professional manner and that they include the information that you intend them to include and not accidentally disclose some private confidential information. When it comes to social media, we could talk for hours about social media. We should probably have a whole entirely new course on social media. But be mindful that your postings will be available to the general public. Remember, once you post something, even if you delete it, there are ways for it to live forever. I can go back to my company websites from 20 years ago and use a tool 15 years ago and 10 years ago and know what it looked like on a particular day, because that stuff is stored forever. Be respectful, be truthful, honor the privacy rights of others, express your own opinion in social media sites. For example, have a statement on your own social media sites to these views expressed on this website, web blog, or whatever it might be, are mine alone and do not necessarily reflect the views of my employer. Do not disclose confidential information about your employer or about your candidates, or proprietary or commercially sensitive information. Be careful. On the other side, remember, in our industry, your employer and you are encouraged, or employer is encouraging, and you are encouraged to utilize every tool that you possibly can to try to make your jobs known and your company known, and to promote your reputation, and to be consultative and to develop leads. And so having things posted to Insta and Twitter and LinkedIn, and join groups and post things and enter into discussions and conversations, to have your jobs wrapped and reposted and propagated out to multiple websites and social media sites and group postings. These are all things that you're encouraged to do. And the more you do it, the more pathways lead back to you, and you are in control of the reputation that you create. On the same token, be absolutely aware that it's possible. I'm going to give you an example. I had an employee, for whatever reason, I don't know why, used WhatsApp to send me a fun picture of that employee engaged with other employees at the work site. There was an award ceremony, and she received an award. I don't know much about WhatsApp, but if you click on that employee's picture on WhatsApp, it opens up a whole nother area of that person's activities on WhatsApp. And there was nothing totally inappropriate, but it wasn't also necessarily there was alcohol and there was dancing, and there wasn't necessarily in keeping with the kind of profile that that individual wanted to project to her employer. So by using a social media account to share information with me, which seemed appropriate and not using the normal channels, all of a sudden, unwittingly and unknowingly, opened up the door for that person to be presenting an image that she did not necessarily intend to project. Be careful. Be careful. Don't say things about your job or your work or your employer or your happiness at work. I mean, I happen to know a person in the United States who works for an airline who regularly on her Facebook account complains about how she's treated at work and complains about how the company treated customers. And it wasn't surprising to find out that when they did a bunch of layoffs, that she received notice that she was included in the layoff. And I don't think she even attributes her selection as one of the layoff people to the notion that for 2 years she constantly trashed her company. But I do. I think that it's unreasonable to expect that they weren't related in the choices that were made. They were layoffs, but they didn't lay everybody off. So be careful. Use the tools the way that they're intended. Try to take advantage of everything that's available to you. Be careful. Principle number 10. We will recognize and respect the rights and privileges of competitors in the true fashion of individual initiative and free enterprise, and we will refrain from engaging in acts of unfair competition. So what do we mean by that? What we mean is that discussing prices and business terms with competitors during a bid process in Canada is illegal. It's considered price fixing. It was originally covered under the Combines Investigation Act and is now extended to the Competition Act, and it continues on. So price fixing, and we often hear about there was a bread company recently that was involved in collaborating with their competition about fixing the prices of bread over a number of years, and they were found liable in a class action suit. There's all kinds of things that can come back to bite you. Do not talk to your customers about your prices, or to your competitors about your prices. Recruiting from a competitor for access to confidential information. It's okay to hire people who work for your competitor. Why not? They might have skills and knowledge and experience and training, and they might be the perfect person for the job, regardless of whether or not they work for a competitor or not. But if the point or intent is for you to ask them to violate the terms of their employment agreement by disclosing confidential information, or to breach their fiduciary duty to act in a protective way towards their employer, then that would be considered unfair competition. Tortious interference is a concept in law where a party interferes with the relationship, illegally interferes with the relationship between two other parties. So heading into a customer and attempting for a workforce transfer. So going to a customer and saying, hey, Mr. Customer, you've got 100 temps that work here, or 25 IT contractors that work here. If you sign a contract with me, we'll let you transfer all those workers over to us, and I'll give you a discount. That is tantamount to stealing. That's collaborating with your customer to get access to confidential information about the competitor's workforce and stealing them. Which doesn't mean that a customer can't go to tender and say, hey, that contract is over in 3 months from now, and it was a 3-year contract. And at the end of the contract, the employees have the right to choose who their employer is, or apply anywhere they want, or come and work for us or something. There's all kinds of legal ways to end a contract. But to tortiously interfere with the relationship that exists by stealing confidential information or some other interference would be a violation of fair competition. Knowingly to multiply submit a candidate. So if you know that your candidate said, yeah, I submitted my resume there yesterday, and I think that this other employee had put my resume in there today for a different job. I've got both those jobs covered, one by me directly in this department and one by the other. For you to turn around and resubmit that, hoping it slept through the cracks while the others would miss, would be an unfair use of confidential information. Abusive market dominance. So if you, this is the law, if you dominate a marketplace and you're the only competitor in that space, and you use it to manipulate prices or contract terms, that's considered to be illegal. Okay, this is not a great question. I just want to put it out to you that you, and we're going to take a break in 3 minutes. You have a walk-in candidate, spend a few minutes with them, you understand the type of work they're looking for, you find out that person does not have the skills that you're currently recruiting for, and maybe that you never recruit. And you're aware of the market, including your competitor specializations. What do? They give you a bunch of examples here. I mean, let's talk about, I'm not going to read the examples, but, well, you can read them. But the answer to this is, you can do whatever you want, so long as you're not misleading. If you say to the person, hey, don't go apply with other people, I got you covered, so that you can kind of protect that candidate to be yours and only yours, that's ridiculous. Don't do. If you don't ever apply for those jobs, it's best to be honest to them and say, hey, listen, I haven't filled a warehouse job in years. We're mostly office administration and IT. We don't fill labor jobs and whatever. So you might want to look at another company that specializes. As a matter of fact, you can say ABC company is downstairs, and so my friend works over there, and here's a list of ACSESS members that participate in light industrial jobs. You might want to go apply with them, but I don't think I'm the right place for you. That's perfectly fine. That's perfectly fine to give them advice to go look in other places. It's perfectly fine to say, I don't have that kind of job now, but if occasionally we do get them, so hang on to my card and check our website from time to time. and take a look and see if, because we try to keep our postings up to date. You might see something there you really like. If you see something you really like on my website, call me again. And if I see something I think, I'll call you. Those are the interesting things you can do. Just don't mislead candidates in thinking that they're covered and they shouldn't go somewhere else. Principle number 11, our final principle before our break, we will ensure that our clients, candidates, employees are aware of our duty to abide to the Code of Ethics and Standards and such supporting policies and guidelines, and may from time to time be adopted by the association, and we'll undertake to bring any potential infringements before the appropriate association body. So what this means is that let people know that you're a member, wear it like a badge of honor, let people know what that badge of honor means by posting the 11 principles or the Code of Ethics in a public place. And if you know of people who are violating the Code of Ethics and Standards, then please inform ACSESS. Hey, look, we've got a couple of other examples here that we don't really need to go over. They're very similar to the ones we had before. This particular example is about people who are wearing uniforms, and the uniforms use words like blouse and skirt, which implies female. And, the question is, if we have men coming to the job, you would like them to wear white shirts and black slacks also. And by the way, it's unless there's some reason, it's appropriate for women to wear black slacks also. So, you can, when we're in a live session, we would do a role play about it. It's important that when there's implied inferences that we deal with some of the implied inferences and just not let them slide. So wrapping up part one before we go to our break, it's good business practice to audit internal documents and practices to ensure that they don't unwittingly or unknowingly or intentionally contain things that you don't want them to be there. They're a violation of Code of Ethics. Review your service agreements with your customers and your documents that you regularly send out and your templates and your employment agreements and your internal procedures to ensure that they don't include things like codes and language and things that are unethical. Create templates for job postings. Very often, if you work straight from a template, you can have hundreds of templates, but if you work from templates, somebody can vet them first, and you're not going to accidentally have untemplated jobs go to the internet that are maybe wrapped from and include confidential information or use language or things that are inappropriate, unwittingly, unknowingly, and unintentionally, or maybe intentionally inappropriate. Provide thorough training to your employees to ensure that they're aware of this Code of Ethics and all of your legal obligations and professional standards. Promote a culture inside your organization that influences the treatment of all candidates, employees without prejudice. Create a Code of Ethics and Standards and operating guidelines that either at a minimum is the ACSESS Code of Ethics and Standards, but write your own. Make it better, improve it, expand upon it, and post the ACSESS Code of Ethics in your workplace. Okay, it is now 2:38. We are going to come back at 2:50, and we're going to spend 45 minutes on the next section before we're to an hour, 2:50, 3:50. We're going to spend 45 minutes to an hour on the next section. I encourage you to keep your microphone off, stay connected, and we'll be back to talk about now that we're through the Code of Ethics Standards, to talk about business practices and guidelines. I'm going to leave the screen up. I'm going to freeze it, turn my microphone off, and I'll see you back here at 10 minutes to 3. I see that there's a question here. In BC, the wage must be advertised in all job postings. Okay, so there's an interesting bit of information given to us from Beverly that Beverly, I have been teaching employment standards forever, and I have had offices in BC, and I was unaware that the wage must be advertised in job postings. That's the first time I've heard of that. So
hi, Steve.
Hi.
It's this just came into effect just recently to make sure that there was transparency in all wages, especially for women and minorities, that they weren't walking into a job and then what was supposed to be, say, $65,000 a year because you were brown skinned or a woman, that all of a sudden the job was only worth 50.
Right. Okay.
So that's why now in BC you have to advertise the wage.
Right. Okay. Hey, stay on the line there for a second. Don't mute yourself out.
Sure.
During this, oh, there it is. It's saying during this pause session, something's happened to my nav bar. It's disappeared. So I just want to make sure. I guess my video is not turned on. There.
Okay, there you are. Yep.
Okay, good. I just wanted to, and I'm going to change screens. If you could just verify for me while we're talking that the screen just changed to part 2 and part 3.
Yes.
Okay, good. Awesome. I'm always a little nervous after I click on something. Last week, we got about 5 screens into it and somebody piped in and said, hey, well, our screen hasn't changed. So thanks a lot. Beverly, that's great information. Thank you. And that now gives me direction to go get my employment standards information for BC updated. That was something that I had not updated. So thank you for that information.
No
Okay.
problem.
All right. Good stuff. All right. So moving along to business practices and ethics, and we're going to move along pretty quickly through this section. Let's, here we go. Why it's important to have operating practice and guidelines within an industry. Well, let's just look at things like workforce transition guidelines. So we talked about that, a workforce transition when staffing companies are, 2 staffing companies are moving, one contract's ending and another one is starting. We talk about things like, what do we do when there's a strike and our customer calls us to supply scab labor? So what's the policy with respect to that? Determine the right to referral. So what happens if there's 2 people inside a company who are doing the recruiting and 2 agencies submit to the same candidate, and then all of a sudden they want to make a job offer, do interviews? What is what we call the right to referral? The headhunting for staffing professionals, headhunting from each other, headhunting from our customers, compliance with the Competition Act. We talked about that. Assignment completion dates. We talked a little bit about that in employment standards and some of the other issues that arise from that in terms of continuity of employment and notice of termination and all kinds of other issues. Hazardous material in the workplace. We didn't talk about that, but we will talk about that, or it will be talked about in your workplace health and safety session, CPC session. And so, but there are very specific obligations on a high level to do WMIS training for all employees. And then there's work site specific training that is necessary from your customers. So ACSESS has written guidelines about all of these things. They create standards for the industry. There's no need for you to reinvent the wheel. There's no need for you to think that you need to try to conjure the stuff up and maybe get it wrong. Please go to the ACSESS website and take a look at some of the suggestions concerning these issues and including employment application forms. So there's a section on the ACSESS website that is available to, like there's lots of sections. I just selected one of the sections that gives you some ideas of the kinds of things that you can click through to and find documents on compliance with the Competition Act or workforce transfer guidelines or independent agency rules, that kind of stuff. So this is, if you don't have a user login name, this is the type of page that you will get access to, so you can grab that stuff, use it for yourself at your desk, use it for your company to develop your company policies. So we talked a little bit about workforce transfer before, so I'm going to not spend a lot of time on this, but you've been the sole supplier with Thompson Tire, which is a provincial chain, and now they are looking to expand across the rest of the country. They've chosen another company to be their master vendor for their recruitment program. Your company is invited to respond to the RFP process to be one of the top 3 vendors in a sub-vendor or sub-supplier program, and subsequently you do not win the spot to be one of the 3 sub-suppliers to the national master vendor. So you've been asked to work with the MSP to conduct a workforce transfer to basically give access to your existing temporary workers. You're not happy, nor should you be happy. Nobody says that integrity translates into happiness, with the outcome that you've lost the contract, which is going to affect your business on 60 temporary employees working with your client. You worked really hard to recruit and assign these employees. So you immediately get on the phone with them and inform that you no longer have the business with it says Dusty Donuts, and up there it says the Thompson Tire. So there's a mistake on the screen with this customer. As well, you plan an early morning meeting on site and coach them to end their assignment in a week's time, and you will place them with another customer. So what's the real process here? First off, there's nothing illegal, inappropriate, or unethical for a customer to go out to tender. There's nothing inappropriate, illegal, unethical, or for them to want to have a national vendor. There's it totally within the industry standards to have a master vendor and have sub vendors. The issue arises when you've got current workers there, and the normal appropriate approach to this is for the customer to honor the end dates of the assignments that they're on. But you've got maybe two conflicting bits of information. You might have a contract with the customer that says we've got an end date of October 31st, and you might have received an assignment from the customer on October 1st that was a 90-day contract that ends on December 31st. So now we've got a contract with the customer that's supposed to, the master vendor contract or the master contract agreement between your company and theirs, that's going to end, and you've got lots of notice, years notice, since you signed it, when it comes to an end, that it's at the end of this month. So you've known that for years, but the assignment overlapped past the end of the contract term. So the normal appropriate thing for you to do is to go back and negotiate with your customer, say, hey, look, let's allow for a reasonable transition of our workforce, that they can apply with the new vendor or apply to you, or we can find them a new assignment with our company on December 31st at the end of the contract, at the end of the assignment. But we're in the middle of a contractual agreement, basically, because you gave us an order that went to the end of the year. And most customers would allow existing employees to work through to the end of their current natural end date. I don't know that they would want those people to sign another year renewal or 2 years renewal. Or you might be able to go to the vendor and say, hey, we'll keep these people on our payroll and we're a subcontractor. And even though we didn't win one of the 3 subcontractor spots, treat us as a sub vendor for the next little while, honor we're going to honor the pay rates to the employee, we'll honor the bill rates. Or you might say at the end of that 90-day, we'll comply. If you want to renew that 1 employee or that 10 employees, will comply with the new margins and the new agreement. But what you shouldn't be doing is you shouldn't be attempting to cause harm to the new vendor or the customer by ending those assignments early, because we've got a code of ethics violation by encouraging people to leave their assignment early. We should not be penalizing workers from choosing their employer. We should not be providing information to the new vendors or to the customer about the contact information, the phone numbers, the email addresses of the workers so that they can solicit them directly. That's a violation of privacy. So we need to take into consideration, how do we honor their privacy? How do we honor your pre-existing contracts? And how do we respect the fact that these workers are going to have the right to choose who their employer is at some point in time if your contract ends and the new one begins? So that's a real high-level sort of description of the many pages you'll find in the document that's online. What's a bona fide referral from of a candidate to a customer or employer? So when a staffing company here's a poll. Let's take a look at this. When a staffing company confirms via email or telephone that they're going to be sending a candidate over to them within the next 48 hours. So notifying a customer that you're going to send a candidate doesn't really classify as a bona fide referral. In the documents concerning a bona fide referral, you got to send the candidate. And you got to send the information, and meaningful information. The customer agrees to accept the introduction of the candidate or the candidate's resumes from the staffing service. So yeah, when a customer has agreed to accept candidates, that's important. If the customer hasn't agreed to accept candidates from you and you just send them in without really a job order, then that's not a bona fide referral. The staffing service informs the candidate of the name and location of the employer, including the name of the individual who the candidate will report to for an interview. Well, that's part of the process that you say, hey, can I send you your information over to Steve Jones? He's currently hiring and has given us a bona fide job order. Can we send your resume? And they say, yes. That's part of the process, that you've got the bona fide approval from the candidate to represent them, but it's not the only part. You now have to submit that candidate. You have to have approval from the customer to submit candidates. You have to have the job order, you have approval from the candidate, and you have to actually submit the candidate. When the customer is informed of the candidate's name and the qualifications of a resume has been sent to the employer and evidence of the timing of receipt has been established, well, yeah, that's part of the process too. So all of the above kind of fit into this category. It's not one, it's all. Do you have an agreement with the customer to submit candidates? Do you have a job order? Do you have a candidate? Did you get approval from the candidate? Did you submit the candidate to the job order and get acknowledgement that you submitted it? Those are generally the rules. And usually, if two agencies submit the same candidate, when it comes to meeting all of those requirements, somebody came first. Can't both of them have completed all of the conditions at exactly the same time? Questions: who is entitled to the fee when two separate agencies submit a candidate to the same employer for the same job, the same day, and within the same hour? Wow. It's who came first to start off with, and did all of the conditions exist? Was there an agreement between the customer? I'm not going to repeat the things over again. Was there an agreement to submit? Did you get approval from the candidate? And so if that's the case, then you tend to want to talk to the customer and say, hey, here's the standard. And you can go to the ACSESS website, you can download the standard, and you can send that to your customer. And your customer can use that industry standard as the sort of criteria to determine who's going to get access to the fee. How can
Sorry. Hi, Steve. Hi, my name's Krista. I'm just curious because I've had this happen where I've dealt with a candidate that has also dealt with another agency, and the candidate is like, oh, they put me forward, but I didn't know. So in that instance, would all of those qualifications have been met?
Well, if yeah, listen, that's a good question, and there's never really going to be a good answer. How would I handle that? I would ask the candidate, do I have your permission to submit you to this job? And if the question arises, would you answer I'm not coercing you to answer it this way, but if you're asked the question, is your honest answer that you did not authorize the other company to submit your resume? And if the honest answer is that you did not authorize the other company to submit your resume, then I will submit this on your behalf. I think that you should pick up the phone and call your customer and say, hey, I've been working with this candidate for the last week, and we got to the point where we were going to submit the resume to them. And they informed me today that they believe that their resume was submitted to you without authorization from another agency. I'm going to submit this to you, and if you see a conflict, let's get an email back and forth and some documentation so that if this becomes an issue somewhere down the road, we can deal with it. So basically what you're doing is you're saying you understand the criteria for a bona fide referral. And if your candidate is telling the truth, then it shouldn't be an issue for the customer. Now, by the way, this doesn't stop the other agency from turning around, say you do the placement and you charge them a fee. This doesn't stop the other agency from trying to file litigation against your customer and say, hey, we submitted this and you owe us the money, but it doesn't mean that they don't owe you the money. And so your customer, probably should notify the other agency that they're not accepting that application. For reasons of conflict, unfortunately, we cannot accept this resume as a bona fide application. We will not be considering this application through your agency if they are hired. If you want, so that, that's the appropriate response. What you described is not as typical as this. What's more typical is that two agencies submit a resume by email into a pile, to the same recruiter or manager. The recruiter or manager is not using some sort of sophisticated system that documents when resumes are done and what the workflow is and where they are in the process. And, you submit it first and the other agency submits it later in the afternoon, but the customer reads their email from top to bottom. So they open the one that came in the afternoon first and they go, boy, this looks really good. Set them up for an interview. And the other agency goes ahead and does, or you're the second one. Let's say you're the second one. I don't know, you're the second one. And you didn't know the first one was in there. And you're the second one. So you do the coordination of the reference checks and you coordinate the interviews and you coach people through and the placement. Now the customer's got a problem because you did 99% of the work and the other person just got there first. The problem would probably not exist over timing if the customer acknowledges the second one saying, by the way, we can't accept this resume. We've already got them in the system. So the customer doesn't have like an obligation to go back and say, we've got this super rigorous time-stamped thing. They opened the other one first. They took you through the process. So it can get unclear. It can get unclear. Important thing is that in order for you to charge, you can't stop the other company from doing whatever they do. It's your obligation to make sure that you check all the boxes for what you do. Does that make sense? Yeah. Okay. Who is entitled to the fee? Two separate, same hour. If you don't know what action to take into a situation, where would you go for the answers? You'd go to the ACSESS website, download the guideline, and you would probably share that with your customer and your candidate and kind of go through the steps to try to figure out who's got the bona fide placement. How can you as a recruiter and a staffing prevent sticky situations like this? Well, have rigorous systems, follow the rules yourself, document what you do, communicate your standards with your customers, and deal with issues in the moment. When you've got something that pops up, then deal with it. There's an expression, kill the monster while it's a baby. So deal with it small before it grows and grows out of control. The last thing you want to do is have two different people at your customers interviewing the same candidate for the same or similar job, for the same job, and following two parallel paths, and your candidate not telling you that this craziness is taking place. Okay, so we've got an issue that we talked about with employer of record. We talked about this before, so we're not going to go over this too much because I think most of you were on the call last week. But let's just talk a little bit about, it's not only is there an employee-employer relationship that exists or an independent contractor exists. But when an employer contract relationship exists, the question is, who is the employer? So we always ask the question first, is this an employee-employer relationship? And then the second question is, who's the employer? And in Ontario, written right into the regulations, it will default to yes, there is an employer-employee relationship, and yes, the agency is the employer, but in all circumstances, that's not necessarily the case. So here we have a scenario. Your customer is a national call center and has 40 of your temps working there. You have received 3 calls from this week from your temporary employees, very concerned and angry, asking why they did not get a gift card at the holiday Christmas party last week that your customer hosted. You also received a call from the hiring manager asking you to deal with these disgruntled employees and ask them to stop bothering him or her about the perks that they didn't get and that they're not privy to. So the first question is, why were the temps invited to the company Christmas party? They're not employees. It was an employee Christmas party. Your temps should have probably been invited to your company Christmas party and them invited to their Christmas party. But at the end of the day, it's not the end of the world. Secondly, did you even know that your temporary employees were being invited to your customer's employee Christmas party? You should have known, because there's issues. Are they drinking? Are they drinking and driving? Are there going to be awards? Are there going to be recognition? Is it a perk? How can you possibly participate in that by giving your approval for them to attend, by establishing what the policy is with your customer and with your employees, and by maybe giving a $50 gift card to all of your workers so that they all received the same gifts while they were there, but yours employees received it from you and theirs from theirs. So did you know that the party was going to take place? Have you spoken with the hiring manager for the last 6-8 weeks to understand that this was going on? You assume that all is going well, that you haven't heard otherwise. No news is good news is not the world when there's an employer-employer relationship. You need to know what your employees are doing. They've been a customer for a real long time. Has this been going on in other places? So you can have situations where there's confusion that doesn't necessarily have to deal with the Employment Standards Act or who's writing the check, but it also can venture down to how does it make your employees feel, and also who's got liability in case something's gone wrong. The employer of record. We talked about this last week, but the employer of record is the one that provides specific worksite training. They determine pay rates, they coach and counsel employees, they manage your workers' compensation, they administer general safety training, they provide employee perks, they supervise employees at the worksite, they determine the length of the assignments, they have the right to hire and fire. And so when we say that in Ontario, you automatically default to be the employer of record, and in other provinces, you probably default to be employer record, they look at, I gave you an entire document last week and we went through many pages of examples, but again, the term is on balance. So on balance, the reason that the Ontario government clarified this and put it into statute is because the temporary help company does set your pay rate. They tell you how much you're going to get paid. They coach and counsel you in between assignments, before assignments, when you go to assignment. When there's a problem, they pick up the phone and should talk to you. They do pay and manage the workers' compensation. They do the administration of general safety, the basic WMIS training. They do provide the perks, so they might have a benefits, or they might have vacation pay or payroll pay, or whatever the perks might be. They don't supervise the employees directly at the work site. The customer might determine the length of the assignment, but you administer the length of that assignment, giving people notification at the very beginning by putting it in writing how long that assignment is going to be, what the end date is going to be. And while the customer might have the right to end an assignment, they don't have the right to fire an employee. So in this particular case, many of the circumstances automatically default to be the employer of the temporary staffing firm. Other aspects of the law can exist where there is a tripartite or co-employment relationship for things like workplace health and safety. If a person receives their high-level training and certification and things from you, and the customer provides work site training and work site supervision, and the customer or an accident occurs, both parties might be, here's this phrase again, jointly and severally responsible for that injury. And so there might be fines, there might be litigation, there might be workers' compensation claims where joint and several responsibility is split and shared between the two worksite employers. So there's a definition of employer-employee for employment standards and for litigation with respect to contracts, but there can be several employers when it comes to things like union, workplace health and safety, violations of human rights, and so on. Scenario number 3, employer of record is expected that staffing service firms retaining temporary orders remit appropriate source deductions. So the temporary companies submitting taxes to the government. If you're supplying independent contractors in temporary employee roles to have cost savings, so in other words, misclassifying a temporary workers as an independent contractor to avoid the paying of those remittances, that is not complying with the law and not submitting the reductions, what can happen? Well, you have to understand your position of supplying a temporary employee versus an independent contractor, that you vet all the specific job orders and work orders with your customers to ensure that you're complying with the legislation appropriately. And misclassifying a person can mean that the governments and various forms of government can go back in time and hold you responsible for the Canada Pension Plan, unemployment insurance, and the provincial federal government. And the provincial governments can take a look at things like payroll taxes, the taxe de santé in Quebec, the education and training taxes and health taxes in Manitoba, the employer's health tax in Ontario. Those things can be charged to you. And so you can find out 3, 4, 5 years later that you owe money on things that happened 5 years ago. We talked the other day about in Ontario, they've allowed information technology professionals to automatically be deemed as independent contractors if they meet the definitions of independent contractor. But in other categories, like administration and labor, misclassifying people can not only have implications with respect to other aspects of the law, they can also have implications to you with respect to your payroll withholdings. Now, by the way, probably too much detail, but misclassifications of tax withholdings is a different issue because typically Revenue Canada doesn't go back and force you to pay the taxes that other people didn't pay if they're misclassified. They typically make you pay the remittances for withholdings on Canada Pension Plan, unemployment insurance, and the employer's portion. But typically with taxes, they try to go back to the employee because the employee received that money and then they go back and get the money. But in the case of Canada Pension Plan, unemployment, and provincial things like employer's health tax, those are expenses to the company and the employee, shared responsibilities. And so they go to the company to get that first. So managing your business. So we want to try to do what we possibly can to prevent in the areas of prevention and those have consequences. We want to try to manage our clients' behavior, and we do that by having contracts and constant communication with our customers. We want to try to manage our candidates' behavior, and we want to do that by having constant communication with our candidates clarity on what the rules and responsibilities are, and having written agreements and documents. And we want to have lots of reporting, because reporting helps open up the door for us to determine what those standards are. So you go to the members only section of the ACSESS website, and you can download those guidelines, and you can use those guidelines to establish your own company policies and to help with your customers to make sure that they maintain the standards also. So not adhering to ACSESS guidelines could result in one of the following: a loss of credibility within the industry, clients and candidates. Absolutely, yes. Doing things inappropriately, like, for example, supplying scab labor under a union strike, could cause your company and the industry significant harm. Liability resulting in thousands of dollars in damages. Of course it can. If you violate a standard within the industry, like reference checking in the example I gave you earlier, then if you don't have a reference checking policy and you don't, or you do have a reference checking policy and you don't do it, then you could have, in the case of the leather treaty case, hundreds of thousands of dollars in damages. Loss of business ownership, loss of clients, and loss of talent. I'm not sure what fines and things would cause a person to lose their business, unless, of course, it bankrupted them. That could cause loss of business ownership, but certainly loss of clients and loss of good employees can come as a result. As a matter of fact, I think that it's said, and I think it's a fact, that people don't quit jobs, they quit their boss. Very often people are very happy with the job that they do. They wanted to be an actuary. They went to school to be an actuary. They studied to be an actuary. They got certification to be an actuary. They go work for a company to be an actuary. They perform actuarial work, but their boss is a jerk, and they don't get along with their boss or trust their boss or think that their boss is ethical or has integrity. And so they go find another job, and they go looking for a job almost exactly the same as the job they just left, except for they have a different boss and a different company and a different culture. And so we lose good talent when our culture is not one of integrity. People leave their bosses and their companies when they feel like they're not honest, when they don't have integrity, when they don't operate ethically and fulfill certain standards, industry standards. By not following some of these guidelines, we can have injuries that can result in death. The answer to that is yes also. People get injured and die in factories and warehouses and driving and things all the time. And the question is, if you had the appropriate policy in place, could you have avoided that? So the answer is all of the above. Case study, Denny's restaurant. Here's an interesting one. This was a class action suit. So I think everybody knows what a class action suit, that is when many people all have almost exactly or substantially similar circumstances involving one defendant. And so instead of one person, each person suing or filing a case against their employer individually and having 100 cases, they go together and file the case as one case so that the outcome would be the same or similar for all of the participants in the class action suit. So in this class action lawsuit in Canada under the Temporary Foreign Workers Program, which had to deal with the company supplying temporary foreign workers, lawyers of Koski, Glavin, Gordon succeeded in getting a class action certificate and settled for $1.4 million on behalf of foreign workers at Denny's restaurant. So in 2013, in this first Canadian class action suit brought on, there were more than 70 temporary foreign workers, and they filed that class action suit against Denny's in British Columbia, and the outcome was over $1.4 million. The workers alleged that they be paid they paid out thousands of dollars in recruitment fees to somebody, to an agency, but Denny's failed to provide the amount of promised work and failed to pay the overtime and reimbursement for travel expenses that they had offered through the agency. They alleged breach of contract, breach of fiduciary duty, and an unjust enrichment. In other words, Denny got rich and they got poor. The workers maintained that Denny's was also attempting to interfere with or intimidate the workers from participating in the lawsuit. This led to another court order that there would be no repercussions against any of the participants in the action. So anyways, regardless of that court order, approximately 1/4 of the employees chose to leave the class action lawsuit because they were intimidated. And even though Denny's tried to intimidate them, then the court said, hey, you're not allowed to intimidate them. They felt intimidated and left anyways, raising the question about whether they did so out of fear of retribution or hope that they might receive support from Denny's to obtain enhanced legal status. So in other words, they thought, maybe if I don't complain, Denny's will help me with my legal employment status in Canada. And so that is a quid pro quo or a reprisal. So you're going to get punished if you don't. We're going to give you this benefit if you do. So those are the notions of reprisal that we talked about in our last one, and quid pro quo, this illegally offering this for that. Those promised 37.5 or 40 hours per week were paid for any hours that they actually worked. So lots of people were working between 37 and 40 hours per week, and they only got paid for 37. So those who had employment records showing they worked more than 37.5 got their extra pay. And they also got paid overtime and time and a half for the hours worked over 40 hours. They were reimbursed for their airfare to Canada. They were reimbursed the fees that they paid to agencies, because in most places in Canada, it's illegal to charge fees to candidates. And Denny's donated a significant amount of money to a program designed for migrant workers in coming to Canada. So managing unethical client behavior is an issue. And so is there discrimination in the job description or poor quality job orders? Is there any breaching of confidentiality? Is there false information? Were there fees? The issue of multiple exclusive contracts. So customers have a tendency. I talked to a client this morning, by the way. I was pleased to hear the answer, and I didn't speak up. But it was because I didn't speak up because I was pleased to hear the answer. But this particular corporate customer that I do consulting for gave a contingency search order to an agency who is a member of ACSESS. And they, over the course of about a month and a half, they got one good candidate, and they hired that candidate. And they're hoping to get more good candidates. I said, have you got the order out to other agencies? They said, no. We haven't given notice to the first agency that we're going to multiple agencies, and we wouldn't go to multiple agencies unless we give them notice. So in other words, they recognize that because they weren't paying a retainer fee and they hadn't signed an obligation or a contract to provide exclusive contract to the agency, it was within their code of ethics to not give the same job order to multiple companies and imply that they might be exclusive. So that was a good answer from the customer. I don't think we can expect most corporate entities to do that, except for if they sign something. So giving multiple exclusive contracts would be definitely an unethical behavior by a customer. And then managing our candidates if they were the employer of record. So we've got some issues with them interfering with our employees on temp assignment and us interfering with theirs and so on. So communicating with your candidates' employees about a workforce transfer, that would obviously be unethical. So the art of preparation. We want to, when we're doing business with a company, do research on their websites. We want to take a look at their safety records. We want to evaluate their job descriptions, see if they're thorough and if they meet our expectations. Candidates who have already worked there, we can talk to them about what their opinions are of that customer. We can have employees who are working there We can take a look at media releases, press releases, but do your research on your customers and understand them. There is a guy, I wish I could remember his name. I'm not really big on these things, but there's a guy, a Canadian from Winnipeg, who operated a retail organization who's in court right now for sexual harassment and discrimination. And somebody might know who I'm talking about. It's pretty high profile. 20 years ago, we were asked to supply that company with temporary help and recruit full-time permanent employees for them, but the allegations had already started. And so 20 years ago, we refused to supply candidates to that particular company. And here we are 20 years later. He's in court now, and covering all of the incidences that have been covered over a long period of time. Documentation must follow the code of ethics, so we don't have things written into our contracts that are in violation of the code of ethics or the law. Any and all documents can be audited by a third party, so you can have your lawyers take a look at documents and make sure that they're correct. So we recommend that you have your accountants, your lawyers, and your consultants take a look at the things that you have written to make sure that they're all in compliance with the code of ethics standards and current legislation. All communication with customers and employees regarding the performance job descriptions can be reviewed and should be accurate and detailed and frequent. We want to be aware of the roles and responsibilities of the employer of record so that we don't have that scenario before with the gift cards where we've got these mixed messages taking place. So if we're all aware of what people are doing and what our responsibilities are, we can conduct our behavior in a way. And of course, if we're aware of the ACSESS Code of Ethics, and standards, and all the guidelines and policies, we can use those documents to help make our case that we do things in the right way. So we can choose to work with clients that meet our standards. We can choose to set the standard with respect to the use of personal information and have policies around that and systems that support our policies. We want to avoid having a lack of concern for health and safety in the workplace. And we want to do our due diligence with our customers by doing workplace safety inspections. We want to go to the customer site and see it in our own hands. Customers appreciate it. Candidates appreciate it. You can be in compliance with the law. We want to make sure that nobody's breaching any contracts and terms of contracts, and that our contracts are written in such a way that they do cover all the important aspects of confidentiality and others that are covered under this. So now we're just kind of repeating ourselves on that screen. So we want to avoid recruiting from customers and using our membership. We want to make sure that we are not charging our fees candidates and deriving income through candidates. We want to avoid being deceitful with candidates. We want to be stealing away temporary workers from our customers or from our competition during assignments. We want to avoid declaring them as independent contractors inappropriately. And again, we're repeating some screens. Oh, here's an interesting one. Your employee is working with the customer for a 6-month assignment. A week before the assignment ends, the employee applies to an internal job with your customer. You only hear about it when your client calls you to say that your employee went through the back channels to get this job. Is this acceptable behavior? True or false? Well, listen, 6 months from the date that in Ontario, the law is that 6 from the date that candidate was introduced to that customer, you can't charge a fee for it. So it's kind of unethical because you ask people to be open and honest and transparent with you. It's not a breach of the contract and it's not a breach of the law. You would, in that particular case, say, if this candidate doesn't get the job and they come back to work for us, we want to talk to them so that we can help facilitate that process. As a matter of fact, given the fact that this customer, particularly in Ontario, or maybe if you had a temp to perm contract that was 6 months or less, you wouldn't have been charging a fee anyways. But if you had facilitated that, it would have enhanced your reputation as a consultant and an agency, and it would have looked good on you that a good candidate got into a good job, and you would have got the benefit of the reputation for that. But in this particular case, it kind of looks like you're out of control. So you would try to encourage it to work, help it go through. And if they don't get the job, talk to the candidate about their future behavior, that they're more open and transparent. I hear a voice
Hi,
there.
Steve. Yep. Sorry, I have another question.
Sure.
It's Krista again. Just about the 6-month.
What province are you in, Krista?
Ontario.
Okay.
So, what if the associate is sick or has a leave within that 6 months where they're not actually working? Does it get extended or how does that work?
No, ma'am. This is we have this notion in Ontario and in Canada called continuity of employment. So when a person is off sick, their tenure continues. When a person is off on leave, you can't go on a maternity leave, or your tenure continues. The only way that you discontinue tenure is to officially terminate employment. And the law is written specifically in a way in Ontario under the Employment Standards Act that it has to deal with 6 months from the first date that the candidate was sent on assignment to the customer, and has nothing to do with whether it was full-time, part-time, intermittent. All they said was, if you introduce a person to a customer by sending them on an assignment, you got 6 months to make your money. And after that, you're not entitled to it, which doesn't mean that the customer won't decide to make it a 5-year contract or a 15-year contract or a 1-year contract, that they can continue to extend it. That's their prerogative. But if they choose to hire that person, you're not entitled to a fee. So the
Thanks.
6-month rule. Okay. So, we always be talking to our candidates about them misrepresenting their skills, their credentials, and experience. We want to have systems and process in place about double checking it and validating it. There's the whole issue about candidates misrepresenting salary requirements to you and telling you that they need $20 an hour because they used to make 20 or $50 an hour. And so it's okay for you to say, can you show me your T4? Can you show me a pay stub? That's fine. You're allowed to do that. Sometimes it makes people feel a little uncomfortable saying, I don't believe you, show me your pay stub, but it's perfectly legal to do that. A lot of candidates will use recruiters as a bargaining leverage so they can go back and get a counter offer. So be aware of that. You can't stop it from happening, but you can not engage with candidates that you feel are just using you that's a bona fide reason to not represent a candidate and not spend more time with them. If you feel like they're just wasting your time to use you as leverage so they can go back and negotiate counter offers with their current employer. And by the way, you can go to various recruiters' websites and take courses from people about how to how to mitigate the potential of counter offers, how you can coach candidates to understand the ethics and integrity of accepting a job from one employer, then going back and seeking counter offers, or 2, preparing them to hear a counter offer from people. And it's like that's tantamount to the example of the husband and wife have got a terrible marriage and things aren't getting along. And so one party says to the other one, we're done, we're over. And the other one says, oh, I promise I'll make things better. And they go, oh, and go back together again. And then it falls apart because nothing was really fixed. There was just a false promise made. Understanding that the similar kind of thing happens in employer-employee relationships, that if a company and a manager has a particular behavior and a way of doing business, and it exacerbated over time, getting a one-time promise and accepting the counter offers almost always results in eventually within a year or two of that person leaving that company anyway. So, we can prepare our candidates for counter offers in a way that's ethical and educational and helpful. We want to try to talk to our candidates about circumventing us, that if we start to disclose confidential information, what the implications are if they go directly to the client. We want to try to minimize that as much as possible. And of course, we want to deal with that whole issue of false or no references. A complaint to ACSESS must be submitted in writing to ACSESS, the executive director. The executive director will acknowledge the receipt of the complaint and refer the complaint to the ethics committee in 7 days. So when a complaint is made to ACSESS from a candidate, a company, or an ACSESS member about the behavior of an ACSESS member, making the allegation that they violated or violating the ACSESS Code of Ethics and Standards, then the complaint is treated as confidential and goes directly to the executive director. In this case, would be Mary McKinich. And Mary's got 7 days to try to deal with it in an unofficial capacity. So very often what happens is you say, okay, I gotta, let me phone the company. They may not even know that that's a violation of our Code of Ethics and Standards. Number B says a complaint must be submitted in writing to your general manager or HR manager within 3 days of the complaint. And prior to that, there's nothing about it being in writing to a general manager or HR manager within a particular time, but a complaint must be made in writing to the ACSESS Ethics Committee. Ethics Committee will not deal with unwritten allegation. They will only deal with an allegation of a breach of ethics if it's put in writing to the executive director with the complainant's name on it. Although it's kept confidential, there has to be an official complaint from a real person. And if it can't be resolved within 7 days, then that written complaint will go to the ACSESS Ethics Committee, which is a subcommittee of the National Board. It is not the whole board. So only the Ethics Committee, the subcommittee who is committed to privacy and integrity of that complaint, will see the complaint. Number C, a complaint must be resolved by your company prior to submitting. No, a complaint that is submit to your company must be resolved by your company prior to submitting thing. If you've got a complaint that's not resolved, it will go to the ACSESS Committee. But if it is resolved, it's resolved. The executive director can look at a situation and say, okay, this is resolved. It's not going to escalate to the official committee level. A complaint must be submitted in writing to ACSESS Ethics Committee no later than 30 days after the initial complaint. Yeah. So, if an employee, this is sort of weird because normally the complaints are made by, there's not a lot of complaints. Complaints are usually made by one ACSESS member about another ACSESS member. But they can be made by an employee about their employer, and they can be made by a customer about an agency. And so there's no guarantee that it will have followed a particular process in advance, but only that can only be treated as official before it's treated by the ACSESS Complaint Committee. A complaint must be submitted in writing to ACSESS Executive Director, and the Executive Director will acknowledge the receipt of that complaint, and if not resolved within 7 days, will be referred to the Ethics Committee. Okay, so we're on to the last few little steps here. Let me take a look at our time. We've got 15 minutes, so I'm going to move through it quickly. These are bonus topics. They are not on the exam. Maybe they should be. But it's important that people understand the differences of these things. The industry is often asked in our contracts with our customers and in other areas of legislation to have insurance. So we're just going to talk a little bit about the terminology so that we all understand what is meant by insurance and things like indemnifications and holding someone harmless. So first off, there's commercial general liability insurance, often referred to as CGL. And commercial general liability insurance is what I call the Wile E. Coyote insurance. This is when something happens, like the anvil falls on the Wile E. Coyote's head. It's something that we just can't and shouldn't normally predict, like a person slipping on the ice in front of our place, or food becoming contaminated, or a person hurting their chances of having some benefit that they otherwise might have not had it. They had not engaged with the company. So commercial general liability often includes portions or parts of that coverage for things like property insurance in case there's damage of a property, including fire, water, and theft. Very often, the theft insurance is separated out under what we call a rider, or a separate part of the insurance. So you can add the theft rider, what happens if somebody steals from us, but more particularly, we're going to go down to a separate part of theft down below, which is going to pop up on the screen in a second, when our employees or we steal from a customer. So most of the CGL insurance with property insurance for fire, theft, fire, water, and theft, or have to deal with water damage from broken pipes and flooding and theft when somebody steals from us. Errors and omissions insurance, E&O insurance, is what I call agency insurance. This is when, for example, the example that we gave of leather treaty, possibly that would have been covered under E&O insurance. And I call this agency insurance because this insures an agency against the errors that they might commit, or they commit, through in the nature of the delivery of their service. So unlike somebody walked in the front door and the anvil accidentally fell on their head, that would be commercial general insurance, because that's not in the act of performing your service. But in placing a person into a job, the fact that if we had, I'm going to come back to the leather treaty. I'll use that as a different example on a different part of insurance. Let's say, for example, we've got two Steve Joneses. One is an IT professional and one is an engineer. And for some ridiculous reason, we get Steve Jones, engineer, mixed up with Steve Jones, IT professional, and we submit them for a job or send them out on a contract. And the IT professional is sent to go build a bridge. Of course, this is a ridiculous example. It would never happen, but I want to make the extreme to make the case. And so the IT professional doesn't really know how to build bridges and makes an error in building those bridges, and the bridge falls down. Well, we can't be held as an agency responsible for the error in building the bridge, because the company was responsible for building the bridge while they were on assignment. But we can be held responsible for, in error, sending the wrong Steve Jones. So in the act of providing our service, which is providing a contractor as an engineer, we sent the wrong person to the job, or we sent an unqualified person to do the job. And as a result of that, there was an error. Now, this can also happen with reference checks, and it can also happen with educational checks. Did we commit an error in finding out that this person wasn't a nurse? Did we not do our background check and find out this person was not certified to be a nurse in the province that we operate in, and then they gave the person the wrong needle or medication? These are errors in the delivery of the service that we provide. And you can buy errors and omissions insurance for the agency, which is different from errors and omissions insurance that is for the contractor. So in the case of the errors and omissions insurance for the contractor, we can get insurance to cover our contractors for the work that they perform. So in the case of an IT professional who accidentally forgets to close a file properly or do something, and as a result of that, someone breaks into the bank and through a lack of cybersecurity and defrauds the bank by exporting money through the back door and the internet. If it was our contractor who failed to click a button or do a thing that caused an error or an omission causing harm to our customer, the third party, we can buy errors and omissions insurance for our contractors, or our contractors can actually buy errors and omissions insurance for themselves. So typically, if you get inexpensive insurance called errors and omissions insurance, and you're an agency and they're going to charge you $500 or $1,000 for it, that typically would be agency insurance. And if you're paying for insurance based upon the size of your payroll and the number of people that you put out on placements, then that typically would be the errors and omissions, and it's expensive. Then it would be errors and omissions insurance for contractors and the work that they perform. Usually, errors and omissions insurance for the agency is a separate policy. Usually, errors and omissions insurance for contractors is either a separate policy or it's a rider that specifically talks about employment agencies and is added to the CGL insurance. We can have directors and liabilities insurance, which often has to do with the owners and directors and board of directors of a company or an organization or a charity, so that the directors are covered in the event that something happens inside the company. For example, Club Link Corporation had policies with respect to serving drinks to people in their golf courses, and having a policy about cutting off people, not serving people who were obviously drunk. And so there was the safe serve, rules and certifications for servers, and there's training, and of course, many years ago at the Lake Joseph Golf Club, a bunch of younger people, 19, 20 years old, came to the golf course, drank a lot, went into the clubhouse, drank a lot, and their keys were taken away from them. And they said, look, you're going to have to give us your keys and we're not going to serve you anymore. And these were members and children of members. And they took the keys away, but they had another car in the parking lot, and they went out in the car parking lot, and just a few miles down the road got into a terrible, sad accident on a bridge. And the car went into the water, and some people died and other people were injured. And lots of people were sued. There was automobile insurance issues, and there were drivers who were sued. But ultimately and eventually, the families sued Club Link and the board of directors and said that the board of directors, 200 miles away, sitting at a board table, were held liable for not having policies in place. Well, two things happened there. Number one is the director's liability insurance that Club Link held paid for the defense. So it paid for the lawyers who were defending Club Link and defending Club Link's board of directors. And it also, they also won the case, finding that the board of directors were not liable because they had sufficient policies in place. They just weren't adhered to by, and they were adhered to because they took the keys away. They didn't have an obligation to walk out in the parking lot and watch the people get into a separate vehicle and to determine what that meant. Was there another driver in that car? Was there somebody sober in the group? That kind of thing. So had there been a violation of the policy, then the director's liability insurance would have covered the damages to the directors, unless, of course, director's liability insurance does not cover criminal acts and known acts of willful neglect. But usually so if directors in the Ford Motor Company Pinto from the 1970s issue they knew that the car exploded. And so they did the math and said, we're better off to ignore the fact that the car explodes, because by the time we sell these cars and make our money from the sale of these cars, it will pay for the lawsuit. And so in that particular case, likely the insurance would not cover the directors who were involved in making that decision. So there's directors' liability insurance, which usually has to deal with policies, practices, and higher level decisions. We talked about theft and dishonesty insurance up above, where I said the commercial general liability insurance covers when someone steals from your company, which the expression is that the thief.
Hi, Steve.
Yes.
My name's Heather. Sorry to, I just in regards with the insurance, I have a client that we had to obtain insurance, and it's called third-party crime coverage.
That's the one we're talking about right here.
Got you. Okay.
Okay. Perfect question, right timing too. So third-party crime coverage used to be called bonding. They'd say, are your employees, see, I've got the little, if you can see my fingers, quote, are your employees bonded? And what that means is, do you have insurance that protects the third party, not you? As a matter of fact, I'm going to go back 1 second, say that in the commercial liability insurance that's got theft, that's when the thief has a manifest intent to cause harm to you. So you've got a company, you've got general liability insurance, it covers theft. Somebody steals from you, they know they're stealing from you, you're the victim, they're the thief. That's normal theft insurance. That's like having theft insurance on your house. The thief broke into your house, they knew they were causing harm to the homeowner or the people who own the property, they stole it from you. In third-party crime insurance, this is when you send an employee to a customer and the employee or the contractor steals from the customer. So the third party is the customer. The crime is committed by your employee. So now the question is, does your insurance cover you, the employer, for the damages or cost caused by your employee stealing from your customer? So an example of this would be, you go to the bank, another example outside of our industry, where you go to the bank, you deal with the teller, and the teller steals money from your bank account. So the bank would have insurance to cover when somebody steals from the bank. But in this particular case, they kind of stole the money from you, not the bank. I mean, it went through the bank. So the bank wants to have bonding insurance to ensure that if one of their employees steals from a customer, that's covered also. In the temporary staffing and contract industry, we send our employees to go work at the customer site. The leather treaty case that I showed you earlier, the agency sent a worker placed by the agency to the customer site. I'm going to come back to that in a second again, because it's not a great example. When you send your employees or your contractors to a customer site and they commit a crime there, they don't cause harm to you, they cause harm to the customer. The customer sues you for the damage. Third-party criminal insurance is when you've got this theft and dishonesty insurance or bonding to cover your contractor's employees' actions causing harm to the customer, not to you. Very often, they'll use the expression, do you have third-party criminal insurance? That's this insurance. Very often, they'll ask you, are your employees bonded? That means, are they insured? That's more of a British old term, which means, do you have insurance to cover them? And then very often, you'll say to employees, or they used to say to employees or candidates, are you eligible to be bonded? That's code for, are you free and clear of criminal offenses for which I can get insurance to cover you in case you steal from my customer? Okay. Now, Here's an interesting one. Let's go back to the leather treaty case where it was an employment agency placed a candidate. So they're no longer an employment agency employee or contractor. They placed a candidate in with Leather Treaty who worked there for 2 years as an employee of Leather Treaty, and then they stole. So when Leather Treaty sued the agency, they couldn't sue them under the third-party criminal or theft and dishonesty bonding insurance because they weren't their employee. They couldn't sue them under commercial general liability insurance because the theft was not committed to the agency. What they sue them under is errors and omissions insurance. And they say the agency failed to do its job in the provision of its services to do reference checks, and they charged a fee for it. So in that particular case, it's really confusing because it is a theft, but it's not what we're suing the agency for. We're not suing the agency under their theft insurance. We're suing them under their errors and omissions insurance for their failure to, they omitted to perform the duties of their service. There's another thing called professional liability insurance, and that's where you as an employer have insurance to cover you against being sued for things like violations of human rights, violations of safety, violations of contract terms. You terminated someone early, and they say, oh, that's unlawful dismissal. You didn't pay me enough money. So when a person gets sued and looks for a payout of 6, 9, 12 months because they thought they were improperly fired, companies can buy insurance for professional liability. So an employment agency that's got professional liability insurance is probably insuring themselves against things like harm caused to a recruiter or a person working in the accounting department, not the temps and contractors out on assignment. We've got temp and contractors insurance for that, workers' compensation insurance for that, directors' liability insurance for that. But professional, if we got sued, if a temporary worker sued you for unlawful dismissal, then you would take a look to see, do I have professional liability insurance to cover us for that? And then there's other special insurances that are often very specific that cover things like medical malpractice if you're placing nurses and doctors on assignments, caregiver abuse policies in case you're sending caregivers out to look for the aged, for the elderly and seniors who might abuse those people. And then, of course, there's 2 different types of automobile insurance. There's 3 types. First off, you and I, we all have insurance to drive our own cars. In most provinces, all provinces, you're not even legally allowed to own and not only allowed to operate a car unless there's an insurance policy on that vehicle for the damages caused by anybody driving that vehicle. Doesn't have to be the owner. And then companies can have their own vehicles. And so companies go out and get insurance to insure their own vehicles. And then, so that's the same as you and I owning our insurance on the vehicles that we own. A company is obligated to go out and get insurance on the automobiles that they own. So then you get into this weird case where a company owns an automobile. They're not supposed to go out to the employee and say, go get your own insurance on it. If the company owns the automobile and says to the employee, you can drive it, the company's supposed to be the one paying for the automobile insurance. And then we've got the circumstances that most of us fall under, and that's where we drive our own vehicles to do company work. So I drive my company to do my car, to do company work, and I have my own insurance policy in case I get into an accident and cause harm to someone or myself. But the company should have what's called non-owned automobile insurance, which is a buffer that goes above and beyond what the individual, what I have on my car. In every province, and we'll talk about again, Ontario, has something called SABS, SABS, Statutory Automobile Benefits System. And SABS says, if you get in a car accident, you got to pay so much money for this, so much money for home care, so much money for an injury, so much money for a death, so much money, you can have it for 2 years, you can have it for 1 year. It lays out exactly, so it tries to reduce the amount of litigation that takes place by saying every insurance policy in Ontario for a car must meet the minimum SABS requirements. You can pay for better, but it must be the minimum. But very often, when a person is driving their own car to do work for their company and they cause an injury to themselves or somebody else, they sue the driver of the car, SABS kicks in, our own personal automobile insurance kicks in, and then they sue the company also for more above and beyond that. And so the company wants to have what's called non-owned automobile insurance to cover them for the excess coverage that's required if an employee is driving their own vehicle and the insurance that they have on their own vehicle is not enough, or if they are jointly and severally liable. So if a company, say for example, doesn't check to make sure that their employee doesn't have adequate driver's license or insurance, and then we send that employee out to drive their own car, and they cause harm to someone other themselves, then the person who was harmed is going to sue the employee, and they're going to sue the company, and the company might be really on the hook because they failed. Not only were they encouraging the person to go drive their car, but they also failed, they were negligent in checking to make sure that person was qualified to drive that car. So you want to have non-owned automobile insurance. And very often when people have non-owned automobile insurance, it causes them to now be more vigilant because they go, bully, we've got non-owned automobile insurance. We better do a background check on this person to make sure their driver's license is valid. Just the same as when they go out and get bonding insurance or theft and dishonesty insurance, they say we better do a criminal background check and our reference checks because we're going to pay these thousands of dollars in insurance policies. And if something happens, they won't cover my dude if we haven't done our due diligence to ensure that they're not there. Yeah. And we have workers' compensation insurance, which is legislated federally, pushed to the provinces, administered by the provinces. And what provincial workers' compensation in Ontario is called Workplace Safety Insurance Board, WSIB, other provinces, WSB, or WCB, Workers' Compensation Insurance. This is legislation that restricts an individual's right to sue their employer if they are injured in the performance of their work duties. So just like SABS, the Workers' Compensation Board has a benefit schedule that says if you lose your finger, you get this. If you lose time from work, you get that. If you lose time from work, you get a certain percentage of your income. If you lose time from work, you get to be retrained, or you get medical or physiotherapy or occupational therapy. These are all set in a schedule by the Workers' Compensation Insurance Board. And it says if you collect workers' compensation, you must collect workers' compensation. You cannot sue your employer for it. And you would have to prove total gross negligence and willful intent to have a separate lawsuit above and beyond workers' compensation. So you'd have to say, I knew that the submarine was likely to explode when we went down to go look at the Titanic. I knew it. We can prove you knew it. You knew you were sending me to a death warrant by putting me in the submarine in my job to go down below. And as a result of that, I'm not only intended to get workers' compensation for this injury, but we're also going to go to the errors and omissions insurance and the commercial general liability insurance and the professional liability insurance and sue people for all of their money outside of that. But if it was just in the course of a person doing work, typing, carpal tunnel syndrome, slip and fall, automobile accident, then the workers' compensation insurance should cover those things. And the terms additionally, I think I'm sorry, I've gone over. I apologize. The terms additionally named insured. So every policy has the named insured. That's the company that bought the policy and who it's intended to cover. And so if you go out and get theft and dishonesty insurance or commercial liability insurance, you can have something called additionally named additionally insured, not named insured. The named insured is the person who holds the policy. You can say this has also additionally insured my customer, and you can name a customer who is also covered underneath that policy. And so there, there we go. Sorry, I hit too many things there. So there was our last screen. It looks like that. Boy, I went over today and I apologize for that. Normally I really watch the clock, but I guess we got into the insurance and I took it on a little longer than usual. Can I open up the floor for anyone to ask any questions about the second half of our presentation today, particularly some of the things towards the end, like insurance? As always, I think that I either put you to sleep and you don't know what to ask, or you went off and left your camera and your thing and did some other work, or it was so darn awesome that you don't have any questions. I'm going to go with the darn awesome for today. But if you do have any questions, my email address is steve, steve.jones, JONES, @bell, BELL.net. I have other email addresses, but that one, everything seems to wrap under that place. So you might as well send it directly to that one. Please ask me if you want, copy in Jennifer Trayer at ACSESS. I'll try to answer. I do have one more complicated question to answer for somebody from last week who I think missed the session and listened to the recording. So not you. Please send me your questions. I'm glad to respond to them and help you out. Also remember that your decision to take your CPC designation is a commitment by you professionally to show that you're committed to be better at what you do, to do a great job. And when you do receive your CPC, I encourage you to get your business cards reprinted, to put your CPC on your email signature, to tell the world that you are a certified personnel consultant. Wear it with pride. Use it to your advantage in your marketing and in your in the development of your reputation in the marketplace. I know that this means that you're going to be successful. There's already great evidence that shows there's longer tenure and higher success by people who have made a commitment to their CPC than anyone else in the industry. The average for newcomers to the industry is 2 years, and the average in the industry, they come, they try, they go. But those typically who have taken their CPC last well beyond the 5-year term. We can't even give you an average because it would include people like me who've been around since the beginning of all time. So use it to your success. Thank you for your commitment. Thank you for your membership and ACSESS. And good luck in your challenge exams. And I hope you enjoy the sessions that you still have coming in the future. Have a great day, and thanks a lot for joining. Bye.